Last time, yeah. Instruction not look at that's the key. I don't go to no. So
So cosa te vuole?
Your Lordship.
Yes.
I'd like to mention item 10, Your Lordship. Here, I'm praying on behalf of Livika, Your Lordship. Here she's yet to file additional affidavit. So kindly grant 3 weeks time, Your Lordship.
Item number 10,
Yes, Your Lordship.
on the appear being made by Ms.
Inaholi on behalf of Livika.
Ina Holi, appearing on behalf of Ms. Ina Holi, learned government advocate,
Yes, Your Lordship.
with consent from the other side. List the matter on
After 3 weeks, Your Lordship, to file additional affidavit, Your Lordship.
2 weeks,
3 weeks, Your
3
Lordship.
weeks, so as to enable her to file additional affidavit.
Yeah.
Fair.
Your Lordship, so similar prayer on behalf of Livika, item 20 for hearing, Your Lordship. Will be listed after 3 weeks, Your Lordship.
Okay,
Much obliged. Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 13 to 15. Lordship, in these analogous matters, we are currently representing only one government respondent. That is item number 14, WPC 216 of 2023. However, Lordship, we are instructed to represent other two government respondents too.
yeah,
That is WPC 215 of 2023 and WPC 2017 of 2023.
yes,
So Lordship, we will file Vakladama for item number 13 and 15 today. And Lordship, kindly grant us 3 weeks to file our affidavit.
Your good name?
Yakasumi, Lordship.
Mr. So-and-so, learned counsel, appearing on behalf of respondent number
7
7, with concern from
for
the
item
other
number
side.
14.
Price for listing the matter after
3 weeks, Lordship.
3 weeks, so as to enable him to file affidavit in opposition.
Yes, Lordship.
Pair allowed.
My pleasure, Lordship. I pick Termination admission item number 9. It's fixed to the body, your Lordship, the counsel for the other body is absent duty, so I feel that the matter may become of week.
After a week,
Yes, Lord. Item number 9.
Mr. Sopongwate Waling, learned counsel for the petitioner. Price for listing the matter after 1 week. You inform the other side.
Yes, Lord.
Okay. With consent from the other side.
Lordship.
Yes.
My blessed Lordship, I pick to mention item number 11. I made a receive instructions, so kindly grant me 3 weeks time.
What is your name?
Bichano
And so, learned counsel, appearing on behalf of,
for the state.
appearing for the state, with consent from the other side. Price for listing the matter after
3 weeks.
3 weeks. Any objection? No.
Lordship, similar prayer with item number 16.
16. Yes, 16. After?
Lordship, I also like to beg to mention item number 12 on behalf of Supung Chan. Kindly
Item
list
number 2,
12.
12.
Yes, Lordship.
What's it?
Kindly list this matter after 3 weeks.
Okay. You are appearing on behalf of
State.
state. Okay.
I'm appearing for the petitioner.
Petitioner.
Yes, sir.
Any objection?
No, madam.
No. Okay. Thank you. Yes,
Item number 16, Lord.
16. Okay. Your good name, please?
CD rooms, Lord.
Okay. CD Luxon, learned counsel for the petitioner present.
Please, Your Lordship. Lordship, I'd like to mention hearing item number 17 and 18, Your Lordship. Lordship, here, the petitioner has passed away, Your Lordship, just a week back.
Hmm.
So right now the family is in bereavement and we are not sure if the family members will be pursuing this matter, Your Lordship.
Hmm.
So if this matter can be listed after 4 weeks, Your Lordship, so that we can get the necessary instructions from
Hmm.
the family members.
Miss
Miss Lucino.
Luciano, learned counsel for the petitioner. Submits that the petitioner or both the petition.
No, Lordship, here, in item number 17,
Yes.
is for the petitioner, and in item number 18 is, the respondent number 4.
Okay, 17 petitioner suffered demise, and as such she is awaiting instruction from the family members of the petitioner, and price for granting her 4 weeks.
4 weeks, Lordship.
Pair in 18 you were for the respondent.
Number 4.
Respondent
the
number.
right person.
I'm for respondent number 1, 3, 3.
1 to 3 in 17. Okay, okay. Record his presence.
I'm for the respondent number 4 in item number 17 and the petitioner in item number 18, my lord.
Okay, okay.
Much obliged.
And Lordship, I also beg for your indulgence in item number 20, which was mentioned earlier, Lordship.
Yes.
Here there's an interim, Lordship. This is.
Okay,
this
interim
item was
was
mentioned.
Continue.
Much obliged.
20 interim continue.
May it please your lordship, I beg to mention item number 19 from the hearing list, F82 of 17.
Yes,
Your lordship, this matter has been wrongly listed today. The letter
Acha.
of absence is still today, 22.
acha,
Yes, and as such, I humbly pray to let this matter come up in due course.
okay. As prayed for by Mr. Your good name,
Mayor, sir, your lordship.
counsel for the petitioner.
Yes, petitioner.
Price for listing the matter in due course.
Yes, in due course.
Fair
Your lordship.
Mr. Lordship, I'd like to mention item number 8 on behalf of my senior merchant. Your Lordship, if this matter can be come up after a week.
Ms. So and so, learned counsel appearing on behalf of Mr. Mausame. Learned Counsel for the petitioner pays for listing the matter
After a week.
after a week.
Lordship.
For motion, item numbers 1 and 2.
Lordship, I have filed the IN, praying for my Lord's indulgence. In making a correction in the cost letter, Lordship, instead of 380, 379, in the first page,
Yes,
380 may kindly be inserted, and instead of 447 IBC, 457 IBC may be inserted. If I may be allowed to make that correction.
give me any objection? No objection. Heard Mr. Sengdi
Sengdi
Anger, Learned Counsel for the applicant, and Mr. K. Angame, Learned Counsel for the, no, Learned PP for the state respondent. This interlocutory application is preferred by the petitioner. Now, by the applicant city, Salang Au for correction of cause title in criminal revision petition number 2, which in bracket K of 2020. Mr. Santianger, Learned Counsel for the petitioner applicant submits that in the cause title of the criminal revision petition number 2 of 2020, the sections is mentioned as, no, it has been inadvertently mentioned as impugned judgment and order dated 38/6/2014, passed by the Learned Chief Judicial Magistrate Kohima, Nagaland, by which the appellant was convicted under section 379 and 447 IPC instead of section 380 and 457 IPC. And therefore it is contended to allow this application and to make necessary correction in the cause title. Having heard the submission of learned advocates of both sides, I have gone through the petition and also gone through the petition, and accordingly, the petition stands allowed. In the cause title of the petition, instead of section 379 and 447 IPC, the same shall be corrected as 380 and 457 IPC.
Deeply obliged, Lord.
In terms of this IAS disposal.
Lordship, if the part-heard matter can be taken up as the first hearing item today, Lordship.
Today,
After, yes, after admission, Lordship.
no, it is yet to be corrected. No?
Yes, Lordship.
Are you ready?
Yes. Even now, actually, I don't know, if you cannot take up now, there's another hearing that.
There.
Yes. So, okay, okay. Then after admission.
After admission, only one item is remaining, one.
So you are ready to argue?
Please.
Okay. Argue?
Obliged, Lordship.
For admission, item numbers 3 to 7.
Your worship, this review petition was filed under section 114, read with the order for dismissal, one of the.
Yes.
Your worship, here, this application was filed under section 114, read with the order for dismissal, rule 1 of the Code of Civil Procedure, read with chapter 10 of the Gauhati High Court rules. Your worship, here, this review was filed against the command judgment and order dated 2019, passed in WBC 202 of 2017, WBC 201 of 2017, and WBC 237 of 2018.
Yes,
Your Worship, here it is clearly provided under order 47 of the CBC, subclass 1, subclass C. But at the time of hearing, at the time of passing of the order and the those repetition, the applicant, the state applicant would not bring a report regarding the benefit earned by the respondent petitioners earned during their work test time. So it could not be brought to the notice of the court and the command judgment not passed. So in order to rectify it as provided under the order 47, rule 1C, which the provision clearly stated that Your Worship, I am under order 47, rule 1C, clause C, provision. C is a by decision on a reference from a court of small causes, but
Yes.
it is not the and who from the discovery of new and important matter or evidence which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order made. So here, that is, this a review petition is a, means apparent error that is very clear. But in the provision itself, when there are certain material, vital material evidence could not be produced by the party during the time of the hearing, so the provision is given. So you must be the applicant, we are on this. But that increment and all the service benefit which the petitioner ought to have enjoyed during the work test time. It was already included as per the ROB 1993, but it was not brought to the notice of the court. And in one way, it is on the lapses on the part of the state respondent applicant because we could not place before the court the very fact. But now it was allowed to pass like that, and now we are coming under the provision. So the petitioners, of course, there are two reviews, two repetitions passed by one command judgment. So these are locus and all are set. So all the petitioners, those who are responding here in the review petition, we have already considered their service benefit like increment and whatever they are entitled as per the ROA 1993. But it was not brought to the notice of the court while those repetition was pending before the court. So that is a humble submission before Your Lordship. Your Lordship, here against that judgment, common judgment, we have not filed any appeal except this review. And again, in the meantime, while processing that the direction of the Honorable Court, again the petitioner respondent, they have filed one contempt motion. But that contempt motion, since it has all clubbed together, I just want to give a submission in common that actually that.
so all these review petition are arising out of the same judgment,
Yeah, common judgment.
common judgment.
Means arising out of three big petitions. So here, the applicant respondent, they have filed another petition against this, again, at the same time, another contempt was filed against the applicant here in this case. So Your Worship, that's the only submission before Your Worship that those increment and benefit earned by the petitioner during the work test time. We have already considered at the time of the regularization of the service. But it was not brought to the notice of the court at the time of the hearing. So that is my humble submission before Your Worship.
So in which paragraph of your petition you have mentioned it?
Your Lordship, here,
Right now we are taking up this
Eight.
review petition number 8.
yes. Your Lordship,
At
beg
which
to,
paragraph?
page number 28,
28.
yes. That's the paragraph 8. Your Lordship, here we have just
Page number 28.
28 of my review petition.
Yes.
So here we just to illustrate that the system which we have worked out is pertaining to petitioner number 16. So, Your Lordship, may I read?
Yes, yes.
For instance, the page 28, at the time of regularization, as on 1/2011, the opposite party petitioner number 16 was serving as bail assistant and was enjoying the basic pay of 1660 as per ROP rules 1993. Since her appointment in the year 1987, she has been serving as work judge for the past 24 years and enjoying the scale of pay under ROP rules 1993. The highest yearly increment earned by her under ROP rules 1993 is 40, rupees 40. Even if the highest yearly increment of 40 rupees is taken to determine the total increment earned by her in 24 years as work judge employee, it will come to 40 into 24, means 960. Therefore, if the said total increment of rupees 960 earned by her is added to the basic and last basic pay of rupees 1660 enjoyed by her at the time of regularization, the total basic pay will come to rupees 2620. However, on regularization at the time of fixing her basic pay under ROP 2010, instead of 1620, her basic pay was fixed at rupees 3200 by taking the minimum basic pay under ROP rules 1990 as reference. Therefore, it cannot be said that the opposite party petitioner have been deprived or denied the benefit of the increment earned by them as work judge bureau. So that is, in all the cases we have worked out and we have already provided to the respondent.
Yes.
So those are the very vital, and those are has to be ought to have brought in a notice of their place before the two-street petition at the time of hearing, but it could not. So we are just taking shelter under Order 47, Rule 1 of the CBC. So that is my humble submission that there is no, it was not intentional or it was not say, willful. But at the time of hearing, at the time of those proceeding of the repetitions, we could not locate that which we have worked out for the respondent.
Yes. Any other ground?
And also, if the review is not considered, then the applicant shall suffer huge monetary loss, and definitely that will be affected the public offers. So that is my submission before your lordship.
Yes.
My pleasure, Lordship. Regarding the submission said by the State Council, Lordship, the petition brought to the Lordship, they have stated some statements, Lordship, regarding that they index some documents in page 329, Your Lordship, in their review petition,
Page.
329, the next file.
Yes.
Lordship, the last para, Lordship, regarding the calculation, may I read?
Yes.
The last base certificate can be summarized below as on 1/1/2012. Basic pay that is 7,960, dearness allowance that is 65%, as on 1/1/2012, MA that is medical allowance that is 400. So after calculating all those, they have given some amount, your worship, but then here they have not shown any the increments earned, your worship. They have not included the increment earned by the petitioner. And then moreover, on the second page, your worship, that is at page 330. Here on the left side, they have shown time bound scale ROB 1993, that is 1,360, and then at the bottom, regularized ROB 1999, 3,200, initial pay statement ROB 2010, 7,960. That means the petitioner's fee was fixed only the basic pay, your worship, without including all the increment. And then here in the earlier court authorities, honorable court clearly stated that, your worship, the increment earned during the work charge period, that is prior to regularization, that is the work charges are covered by the ROB 1993. So the increment earned by the work charge period by the ROB 1993 should be counted for fixation at the time of the regularization, your worship. This was the case. And then the state respondents, they fixed the petitioners at the at basic pay only. They have not included the increment. During increment earned during the
So
work charge
as per
period.
this ROP 1993.
Yes, Lord. Why? Because in the table, your worship, they have just shown ROB 1999 that also 3,200, it is the basic pay, and then the initial pay statement ROB 2010 that also 7,960, that is the basic pay, your worship. That means they have never included the increment earned by me during the work charge period. And then, your worship, this honorable court have disposed this common writ petition by order dated 29/2019, your worship. And then even after that, the chief secretary also issued one of his memorandum, where they have clearly stated that the increments should be counted for fixation, your worship. I mean, we are allowed to place before the worship. Worship, in the earlier proceeding, your worship, this particular document was not, it was issued only in the year 2020, and then the particular writ petition was disposed in the year 2019. But then even in the absence of this obvious memorandum, your worship, this honorable court has clearly given directions to the state respondents to refix their pay by counting the increments earned by them during the work charge period, your worship. And then now may I read, your worship, this obvious memorandum 18 February 2020. Subject counting of increment of work charge employees upon regularization of service. And the matter of admissibility of agreements granted to work charge employees in fixing their pay upon regularization of service, it is clarified that the increments granted during work charge service shall be counted for fixation of pay subject to fulfillment of the following conditions. Number one, that is those getting scale B and if been granted annual increments. Number two, if such work charge service was continuously followed by regularization of service and their past work charge service counted for length of service in pension, your lordship. And then in all these, your lordship, these particular two.
So at
conditions.
the time of disposal of the writ petition, this memorandum was not issued.
Yes, lordship. It was issued on the basis of the one of which memorandum that's saying that the contract employees were counted for fixation for increment, counted the increment for fixing their pay. So this honorable took the view that contract employees and the work charge employees, they should be treated on equal footing, your lordship. For that, I'll take you the relevant court order, your lordship. Page 326 of the review petition, your lordship. Page 326.
Yes.
The second paragraph, may I read, your lordship? It starts, the relevant paragraph starts from here. Furthermore, the fact that the government took a different view in the case of contract employees while fixing their base and allowances at the time of the regularization is also discriminatory. The only difference between two categories of employees is while contract employees are normally appointed against sanction posts, the contingency employees are appointed without sanction posts. But the two categories of employees, especially in the case of the petitioners, they both earned the same pay and allowances as regular employees. Therefore, there is nothing so special about the contract employees which would entitle them to such differential treatment as far as the counting of past increments in the pay and allowances is concerned. The two categories of employees stands on the same footing. As such, they should be treated equally or in the same manner. Lastly, the government employees of every hue earned their annual increments and their base and allowances in such increment are not bounty or a gift from anybody. They are the price of their sweat and they cannot be denied of such increments. Therefore, when the pay and allowances of the petitioners were fixed at the time of their regularization, the increments already earned by them during their work short period as per the provision of ROP 1993 should have been taken into consideration. In view of what is stated above, the prayer of the writ petition is allowed in the Ambient Office Letter, such and such dated 19 April 2001 and Ambient Office Letter 22nd May 2002 are quashed and set aside. Accordingly, the state respondents are hereby directed to fix their pay and allowances of the petitioner at the time of their regularization by taking into account the increments already earned by them during their work service as per the relevant rules of RB 1993, and hereafter refix their later base. However, errors which may accrue and consequence will not be paid to them as it is already been submitted that they are not claiming the same, Your Lordship. This was the case, Your Lordship. And then now in the review petition, the state respondents are saying that they have already granted the increments, Your Lordship. But even the table, they have just shown granting me the basic pay, Your Lordship, as per the relevant ROPs.
So, yes, going by this page number 330, can it be said that as per ROP 1993, the increment was granted to the respondents?
Yeah, Your Lordship. Yeah, whatever we have worked out, it is already in the review application. And these matters are just taken over only recently. So whatever we have, our grievances, we have already incorporated in our review.
No, this is your document, 330.
Yes, of course. So whatever increment, this is a increment, we have worked out at 40 rupees. So it was added on the basic pay. Then again, by the ROB 2010 also, again, we enhanced, now the basic pay has come up to 32, yes, 3200.
So basic pay increment was 40 rupees.
Yes, 40.
So
That is 40 means 24 years. They were, means after 24 years, they were regularized. So 40 to 24 means 960 plus basic pay was 1660.
So it appears that they have added it in the basic pay.
No, Lordship.
So on 1/2/2003, his pay was 1390 rupees. And if we add 40 rupees,
Yes.
then on next date of increment, it is 1420 rupees.
That is under 1993 only, Your Lordship.
Yes,
This is to be included in the 1999 and 2010, Your Lordship. Why?
90,
Because
99.
yes, 1999 and 2010, they have given only the basic pay, Your Lordship. They have not included the increments earned by me during the ROP 1993, Your Lordship. Lordship, for better clarification, Your Lordship, I will allow to place, Your Lordship, the relevant ROP table, Your Lordship.
Yes.
Your Lordship, may I allow to take you to page 332, Your Lordship, of the petition.
332.
332, Your Lordship.
Yes.
Here, Your Lordship, made the reader ROP 1993 as on 21/10/1992, that is 1,000, Your Lordship. And then here the documents which are placed, Your Lordship. And the second table, that is ROP 1993, which is marked, Your Lordship. That is 1,000. That is the basic pay, Your Lordship. After that, in the year 2007, as per the table, Your Lordship, the petitioner was granted time on scale, that is, again, I mark on the same table, that is 1,450-40, 1,610, Your Lordship. And then in the ROP 1999, they've shown 3,200, Your Lordship, in the table. And then in the documents which I've shown, that is ROP 1999, I've clearly marked 3,200, Your Lordship. That is the basic pay, Your Lordship. They're just showing the basic pay only. They've not included the increments, Your Lordship. So this is the reason, Your Lordship. They are saying that my increments have been granted. Yes, during the RB 1993, they've been granted my increments, but then after regularization, my increments have to be put in the relevant RBs for fixing of the pay, Your Lordship. But instead of putting the increments, they've just given me the basic pay, Your Lordship. That is the reason, Your Lordship. The increments have to be counted, Your Lordship. And then as per the table, it is clearly shown that, Your Lordship, they can only as submitted, Your Lordship, only the basic pay, Your Lordship. There is nowhere in the documents saying that my increment is being counted, Your Lordship.
Or Mr. Learned additional advocate general for the state, no, for the petitioner. And Mr. Supungwati Waling, learned counsel for the respondent. Argument concluded, judgment reserved.
Your Lordship, if I may allow, Your Lordship,
Yes.
Civil Review 8 of 2022 is the common review petition in the WBC 202, Your Lordship. So if the particular order may pass in Civil Review petition 8 of 2022, then it will cover all the review.
Okay.
Obliged, Your Lordship.
For admission, item number 26.
Please, Your Lordship. The petitioner was initially appointed as an assistant professor in the year 2009. And despite rendering her service, the salary was not paid. So ultimately, she was compelled to resign. She had to resign from the service. And after resigning from service, she was pursuing for the payment of her wages for the service she has rendered. And then the department admittedly, if Your Lordship may kindly go to the page 26 of the writ petition. In the year 2020, she resigned in the year 2019. And after making so many deliberations and communications, in the year 2022, the department has admitted to the 2-year liability. That a balance amount so was to be paid. The relevant portion will be the last sentence of this document, Your Lordship, where the department has clearly, the university has clearly stated that balance amount of your pending salaries and EPF will be cleared within this month. That is way back in the month of 14 June 2022, Your Lordship.
So this balance amount of rupees 5,54,812, this is admitted part.
Yes. Salary and then EPF, which will be assessed by the department, and then Employees Provident Fund, Your Lordship. So despite this order, they have not paid till date the salary. It should have been paid within that particular month itself. And then day before yesterday, I have received the affidavit in opposition filed by the respondents. And in paragraph 6, they have admitted again. Paragraph 6 of the affidavit in opposition.
Yes.
The second subpara of this paragraph 6 will be relevant. Allow me to read, Your Lordship. However, the deponent states that the university will make all necessary efforts to pay the outstanding dues to the petitioner. However, under the given facts and circumstances, the deponent must most humbly praise that this honorable High Court may please to allow the university to pay the outstanding dues to the petitioner in 3 installments within 6 months' time, Your Lordship. That is what they have stated in their affidavit in opposition.
Yeah, so why this 3 installment in 6 months?
Lordship,
What is the quantum? Quantum is not. very
Lordship,
high.
may I make a submission?
Yes.
I've categorically stated in paragraph number 3, Lordship. But in short, Your Lordship, in brief, Lordship, the university, the problems, the genesis of the problem started in 2013, Your Lordship, when the UGC has issued a letter conveyed its refusal to grant recognition, Your Lordship, for offering programs through distance mode, purportedly in view of the negative recommendation of the expert committee. This was done without even issuing a show cause notice to the university, and neither a copy of the purported negative recommendation of the expert committee was also provided to us. Then being aggrieved, the respondent university has approached this Honorable High Court. Then the Honorable High Court was pleased to quash and set aside the impugned letter issued by the UGC. Again, the UGC preferred writ appeal. Thereafter, the writ appeal was dismissed. And again, the UGC has approached the Honorable Supreme Court, which was also dismissed, and review was also filed by the UGC, which was dismissed last year. So because of the illegal and arbitrary action of the UGC, Lordship, the respondent university was forced to engage in legal proceedings for the last 10 years. That is 2013 to 2023, Your Lordship. And because of these legal proceedings, the enrollment of this in respect of this distance education, it has come down from thousands to nil, Your Lordship. And at present, we are offering 2 courses, that is fashion technology and hotel management. But the university is contemplating to stop the hotel management because of the poor enrollment, Lordship. So this is the problem that the university is facing at this moment. Your
No,
Lordship.
some other programs are also going on.
Your Lordship.
Some other programs.
Some other problems?
Programs
No, Lordship. Now only we are offering only 2 regular courses, that is fashion technology and hotel management.
in distance mode.
Lordship?
In distance mode,
No, regular,
regular.
Lordship.
So this LLM course is also there.
Lordship,
LLM course is also there.
LLM.
Yes.
No, Your Lordship. Now we are only offering 2 regular courses, that is fashion technology and hotel management. Now the university is contemplating to stop the hotel management because of the poor enrollment.
No. Recently, some of the students from Assam appeared in LLM examination conducted by this global university. Are you sure?
Lordship, I'm sure, Lordship. I was told that they are offering only now regular courses on these 2 streams.
No, as far as I know, some of the officers also appeared in LLM examination conducted by this global university.
Lordship, to that regard,
Hmm?
no instruction.
Hmm? So your instruction is incomplete.
However, Your Lordship, the reason stated by the respondent is not a ground for me to be deprived of my
Yes,
salary, Your
yes,
Lordship. And
No, Lordship, we are not washing our hands from our liability, but Lordship, and even in their paragraph number 6 of the writ petition, they have stated that we have made our partial payment before also. So the university is making all efforts to pay.
So are you agreeable to what they have proposed in
Your Lordship,
paragraph
we
number
did-
6?
Of course, some time has to be given, so 6 months is too long. I've already been deprived for over 4 years from my salary. I've resigned in the year 19. And
Lordship,
till date, they have not paid the money, so maybe 3 months, Your Lordship, otherwise I'm also claiming interest here. But if they are willing to do that,
Lordship, it's not that we will pay after 6 months, but in
so
3 installment after every 2 months, we will be paying within the 6 months, Lordship.
a
So I
person,
get,
an employee cannot be deprived of his salary, Your Lordship. It's been more than 5 years. And I've been waiting for the services rendered, the salaries for the services rendered, which I've already rendered. So maybe 3 months, Your Lordship. I also have to show some consideration to the respondent. So let it be within 3 months, Your Lordship.
Lordship, 3 months will be less, Lordship.
Pardon?
3 months will be too less for us.
No,
The university was, already going through a financial.
Otherwise, they have
problem.
calculated that way back in the year 14 June 2020 that they will pay the clear the salaries within that particular month. And after 5 years, in this court, they are saying they need another 6 months, Your Lordship. It's not justified.
Considering the facts and circumstances, Your Lordship, 6 months would be.
No, 6 months will be too long. So within 3 months,
Lordship, 4 months at least.
yes.
3 months, Your Lordship. I think it's a
Lordship, I
considerable,
can't appreciate
considerable amount of time.
the current scenario of the university is facing financial problem, Your Lordship.
Okay, then 4 months.
Okay, Your Lordship.
Close the matter.
Yes, another aspect, Your Lordship, with regard to the employees, EPF, the Provident Fund.
Yes,
The structure of the Provident Fund is a certain percentage will be deducted from the employee
yes,
and a certain percentage will be deducted from the employers and it will be deposited into the employer's Provident Fund. In my case, share, the employee share was deducted.
Mm.
And the employer shares was not deposited in the employer's Provident Fund. So it was not accountable. So there's so many months missing despite my share has been deducted. So if this court can give a direction to assess all those things and then release my EPF also.
Is there any pair in this petition to that effect?
Yes, Your Lordship,
Where?
the prayer portion. Prayer to Your Lordship. To direct the respondents to pay the employees' provident fund along with the missing EPF, which is entitled to the petitioner. Page 11, Your Lordship. Of the petition.
Yes?
Lordship, direction may be given to calculate it.
Pardon?
Yes,
Pardon?
to this regard, a direction may be issued.
Okay. So we are disposing of the petition. Next item.
Like,
We're hearing item numbers 21 and 22.
Please, my lord.
Yes?
Your Lordship, here the petitioner is praying for retrospective regularization, Your Lordship.
Praying for?
Retrospective regularization, Your Lordship. Your Lordship, the petitioner was appointed as word judge, skilled labor, Your Lordship. And after serving the department for 29 years and 8 months, Your Lordship, he was allowed to leave empty-handed, Your Lordship. Your Lordship, may kindly come to page number 17, Your Lordship. Is the appointment order, Your Lordship. The type copy is in page number 18, Your Lordship, the appointment order of the petition.
Yes.
Your Lordship, may I read the office order, Your Lordship?
Not necessary.
And page number 19 is the identity card issued by the department, Your Lordship, word judge identity.
So perhaps they have not disputed it.
Your Lordship, page number 21 is the release order.
After retirement.
Yes, Your Lordship, release order. Dated 29 March 2019.
After how many years of service?
29 years, 8 months.
29 years, 8 months.
Yes, Your Lordship.
So, two office memorandums were there. One of 2004 and the other is of 2015.
Yes, Your Lordship.
Why the, say the memorandums were not applied in his case for regularization of his service?
I beg your pardon.
Why those two memorandums were not applied in his case for regularization of his service?
Yes, Your Lordship.
Why? You could not follow.
Lordship, I was discriminated, Your Lordship. And as per the RTI reply, Your Lordship, dated March 2021, Your Lordship, which I have annexed in, annexed here.
Mr. Santianger. So, two office memorandums were there. 2004 and 2015. So, why those two were not applied in the case of the present petition?
The applicant's policy was adopted, but in fact, Lordship, even prior to 2004, there is another poem, 2000, which was issued in 2001, which said that as per severely, they would regularize. Now, 2004 says that 50% of the vacancies shall be reserved as the regularization of very long, as per available vacancy. And the work charge employees shall be given preference, Lordship. Now, preference was given to other employees. Those 380 employees who were regularized by the department, they are all to do with every single one of them. But I was not considered also.
Yes, madam?
Bless your Lordship.
Yes.
Lordship, I'm relying on my affidavit in the position, paragraph 4 to 8.
Page number?
Page number 2. Page number 2 to 7.
Affidavit in opposition of respondent number 1 to 4. Page number?
Page number 2.
Page number 20.
Page number 2 in my contract, Your Lordship.
Pardon?
Page number 2. Paragraph 4 to 8.
Yes.
Lordship, you can allow me to read.
Pardon?
Kindly allow me to read.
Yes.
That with regard to the amendment made in paragraph 23, the demand responding admitted extend bond by the courts. It is submitted that as per the office order, the amendment is fully temporarily and liable to be terminated without any further notice. And Lordship, page number 6, paragraph 8. As per the office memorandum dated 17/3/2015, all existing workers and casual employees of the rest department who are enjoying scale pay and who have completed 30 years. How Lordship, the petitioner has
Not been granted a scale of pay.
yes. Or
Why?
fixed pay without granting scale pay.
Why?
So the petitioner is not eligible as part of his memorandum. So 17 March 2015.
Why his service was not regularized?
Since the petitioner is fixed pay.
No, why the scale of pay was not granted to him?
Since the petitioner was appointed on fixed pay, Lordship, and it is liable to be terminated at any time.
Yes,
And Lordship, paragraph 9, during his service, the petitioner never made any representation. Paragraph 7, Lordship.
yes,
Yes, during his, the petitioner service, he never made any representations. No, bring grievance to respondent,
no representation was made.
Lordship. He made representations only on 28/7/21.
That's all.
Lordship.
Yes, madam, any reply?
Yes, Lordship, with regard to the contentions raised by the respondents, Your Lordship, I may be allowed to rely on my affidavit in reply, Your Lordship. Paragraph 4, Your Lordship. Your Lordship, may I read?
Paragraph number?
Paragraph number 4, Your Lordship.
Yes,
That the statement made in paragraph 4 of the R1 to 4 AIO is not admitted, for the same is unreasonable, misconceived, and arbitrary. It is well settled that the state cannot be allowed to take the benefit of its own wrong. R1 to 4 have stated that as per the office order, the appointment is purely temporary and liable to be terminated without any further notice. That the order is clear and specific that the appointment is irregular appointment made on temporary basis without following due process and was not appointed against any sanction post. However, the fact remains that the petitioner was never terminated and allowed to continue for 29 years, 8 months, and he was terminated on 30/4/2019 by order dated 29/3/2019. Further, it is clear from the RTI reply dated March 2021, 195 work charge employees were regularized from time to time. Also, as per the RTI reply dated March 2021, 380 work charge employees were awarded scale of pay. Such pick and choose policy on the part of the government by applying different yardsticks to similarly situated employees smacks of arbitrariness and is most unbecoming of a model employer. Furthermore, it may be noted that the government of Nagaland Office Memorandum dated 17 March 2015 does not speak about regularization of work charge employees against sanction posts, but about regularization by conversion of their posts into regular ones personal to the Lordship. Your Lordship, I may also be allowed to place a reliance on the decision passed by this honorable court, Your Lordship.
Yes.
Your Lordship, page number 5, paragraph 6.
Yes.
Yes, Your Lordship, may kindly allow me to read the operative portion, Your Lordship. I have considered the submissions of what the learned counsel, keeping in view the facts and circumstances which have not been disputed. The pay of 380 were charged employees, majority of whom were junior to the petitioner, were upgraded to scale of pay by the department, leaving aside his case. In spite of the applications submitted by the respondent number 3, the service of 195 were charged employees who were all junior to the petitioner were regularized, and that too without meeting the requirements of the provisions of the office memorandum referred by the learned government advocate. I am of the view that the petitioner has been discriminated. Since the petitioner had served the department without any break for so many years, he should have been given the same benefit when he had asked for it, even without asking. The state as a model employer and under a democratic form of government and being a welfare state should have done it. Having not done so amounts to exploiting its own citizens for 35 years and releasing him empty-handed. The fact that his service was utilized till he completed 35 years of service, by which any person serving under the government of Nagaland is to retire, shows that his service was not only required but fully utilized. If a person's service is required and utilized, he should have been given what he has deserved, Your Lordship. Your Lordship, the present case is also covered by the decision of this honorable court passed by the division bench, Your Lordship. If I may be allowed to place this before Your Lordship.
Yes.
Your Lordship, may kindly come to page number 7, the last paragraph, Your Lordship.
Yes.
Yes, Your Lordship. In the instant case, the petitioner was promoted as Tukali, and as noted above, the order of promotion itself stated that he was so promoted against the post of Tukali. It is not the case of the respondents that the office of the executive engineer, the Mabul Electrical Division, the Mabul, was or is a work charge establishment, be that as it may. The petitioner having rendered 27 years of service, it will be unfair to deprive him of pension and other retirement benefits on the plea that he had rendered his services as work charge employee. We find no merit in the appeal and accordingly it is dismissed. Before parting with the case report, we place on record the appreciation for the assistance rendered by the learned amicus. And Your Lordship, I may also be allowed to place reliance on the decision passed by the apex court, Your Lordship. 2019-10 SSC.
Page number?
516, Your Lordship. There were 11 paragraphs in 541. There were 11 paragraphs, Your Lordship.
Yes.
541, paragraph 36, Your Lordship. May I read the relevant paragraph? There are some of the employees who have not been regularized in spite of having rendered the services for 30 to 40 years. For 30 to 40 or more years, whereas they have been superannuated, as they have worked in the work charge establishments, not against any particular project. The services ought to have been regularized under the government instructions and even as per the decision of this court in the state of Karnataka versus Kumadevi. This court in the same decision has laid down that in case services have been rendered for more than 10 years without the cover of the court's order, as a one-time measure, the services be regularized of such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been we direct that their services be treated as a regular one. However, it is made clear that they shall not be entitled to claim in any case of differences in wages had they been considered in service regularly before attaining the age of superannuation. They shall be entitled to receive pension as if they had retired from regular establishment and the services rendered by them, right from the day they entered the establishment and the services rendered by them, right from the day they have entered the work charge and establishment shall be counted as qualifying service for the purpose of pension. Your
Okay,
Lordship,
all right. Not necessary to multiply the decisions. Third, miss, your good name, please.
Vijay.
Learned Counsel for the petitioner and madam,
Pichanogitam.
learned government advocate. Pardon?
Pichanogitam.
Government advocate
Lordship.
for the state respondents. Argument concluded, judgment reserved.
For motion, item number 2.
Right, please, my lord.
Yes.
Lordship, the type, the position of the prosecution witnesses, which I will see from the trial court. Lordship, I have placed.
In the memo of appeal,
No, Lordship, it's not in the memo of appeal, but the original CTC I have placed before, my lord.
these are certified copies.
Yes, the original sealed copy I presented.
But the original one, it should be in the case record of the court below.
Yes, Lordship, but it must be there, Lordship. Must be there.
Okay.
But since this is typed, it will be easier
Mm.
to read.
Yes.
Now, Lordship, at page 2, I have highlighted the relevant portion.
Yes.
Here, they are saying that, Lordship, there were 5 plastic bags.
Mm.
Now, this plastic bag, Lordship, it is neither mentioned in the FIR nor in the seizure document. And Lordship, he says that, Lordship, it is also true that I did not see the accused stealing the goods, but I saw him only after he was arrested.
Mm. So this is the cross-examination of PW1.
Yes, Lordship.
And who is PW1?
PW1, he is I believe that is PW4, Lordship. Yes, PW1 is the complainant. His cross-examination is at page 4. He also has stated that, Lordship, it is true that I lodged the complaint basing on the information received from Sudhir. So he did not see anything. He was not there, Lordship. So basing on the report, he has filed. Now, Lordship.
So this Sudhir,
Yes.
Sudhir is PW? Prosecution witness number
4, Lordship.
4.
Yes. So Sudhir himself did not see the commission of the offense. And he informed PW1, Who also did not see lordship, and based on the information received from Sudhir, that is PW4, PW1.
So where is the
Okay.
evidence of PW1?
PW1, he said lordship page 4. PW1 is K Solo. He is the owner of the house, of the building.
K Solo is PW1,
Yes, lordship, he is the FIR complainant.
owner of the shop.
Yes, lordship.
Yes.
Owner of the house of the shop, lordship, and the owner of the building. In the
Not the
sense,
shop.
the shop is being run by somebody else, lordship, on rent basis. Now he is taking rent, otherwise he is not running the shop on his own, lordship.
Acha. So he got the information from Sudhir,
Yes, from PW4.
PW4.
Yes. Now PW4 reached the place of occurrence, lordship, on the alarm raised by PW2 and PW3.
So who is PW2?
PW2 is somebody who reached the place of occurrence at 3:30 in
No,
the morning.
in this pages where his name is mentioned.
Lordship, page number 3,
Yes. His
Robin
name is,
Mandal.
pardon?
Robin Mandal,
Yes. PW?
3, lordship. PW, this is PW2, lordship.
PW2.
Yes.
So the informant got the information from PW2 and 3,
No, for PW4.
PW4.
Yes. And PW4 reached the place of occurrence on the alarm raised by PW2 and 3.
Hmm.
Now, PW3 is the only person who saw the actual commission of the offense, lordship. Because the case is that at 2 a.m. in the morning, on 24th of January 2011, in the early hours at 2 a.m., lordship, he saw a fat person breaking into the shop.
Hmm.
The examination, the deposition, lordship, examination chief, and the cross-examination is at page 2, and which continues till page 3. I may be allowed to read because this is important.
Hmm.
Tilak Mukhir, Hot Administrator. Presently, I am working as a sweeper in the TPL market, Kohima, and I have been working in this capacity for the last 5 years.
This Tilak Mukhir is the PW?
3.
PW 3. Yes.
He is the only person, lordship, in the
Okay,
entire
okay.
case, lordship, who saw the actual commission of the offense.
Hmm.
Usually, I reach the place where I work at 2 a.m. On 24/1/2011, at about 2, it should be 2 a.m. lordship, as it is reported as 2 p.m. I saw the accused breaking into the said shop and I was alone. I did not raise any alarm or took any step. It was around 3:30 a.m. When I saw Rupi, that is PW2, and met him, told about that someone had broken into the shop and was trying to escape with the items. When I asked to the accused that where the items that he was carrying in the polythene bag, he replied it was feeds for the cows and pigs, but not part of the verification the contents were soap, mild, mustard oil, etc. And after seeing the items, me and Robin raised an alarm, and when the alarm was raised, crowd gathered and public arrested the accused. Now, in the cross-examination, lordship, these statements are very important. I did not raise the alarm as I was alone. However, the person who was opening the lock was a fat person. It is true that there were around 6 candy bags. Now, lordship, there is also contradiction here. One is saying 5 plastic bags, he is saying 6 plastic candy bags. Next, it is true that the 6 bags were lying outside the shop and one was on his shoulder. It is true that there were many people who arrested the accused. It is true that I could see that the accused when he was arrested as there was street light. Now, this is important, Lordship. It is true that I do not know whether the accused is present today. He was unable to positively identify the accused. It is true, it is also true that I always carry a torch and I could see the accused properly on the day of incident. So at 2 a.m., Lordship, he could make an impression of the identity of the person who was committing the offense. He said that he always carries a torch, and the person was a fat person. Now,
No, there's a letter line. It is also true that I always carry a torch and I could see the accused properly
on
on the
day,
day of incident.
yes, Lord.
So thereby he identified the person.
No, Lordship,
Why?
it is true, Lordship, just the line above that, Lordship. It is true that I do not know whether the accused is present today because, Lordship, accused is normally present in criminal trials.
Mm.
So when the court asks him whether the accused is present in the court today, whether
No, is it cross-examined by the court or the defense counsel?
by the defense counsel.
Then it is your cross-examination. You have elicited that the accused properly on the day of incident.
Yes, Lordship. Now, if we could see and if we say that he was a fat person, Lordship, then it is not the accused who has committed the offense, Lordship. Because the accused is not a fat person. And if, Lordship, he is unable to identify,
Mm.
he is saying that no, this guy is not this person is not the one who committed the offense, in other words. Because the accused is never known to have been fat, Lordship, because the fact that he was serving in the police itself shows that, Lordship, he has to maintain fitness.
That kind of presumption cannot be drawn. Merely because he is working in police, we cannot presume that he is a lenient, not fat person.
Now, Lordship, test identification period, Lordship, should have been
Not conducted.
Yes. Because the accused and the witnesses, they were not previously known to each other.
Mm.
So in order to establish the identity of the accused, because Lordship, it goes to the root of the matter. The identity, Lordship.
May not be because in all cases this TIP is not necessary.
Yes, Lordship. But when the accused and the witness, they are not previously known, because this is an important witness. He is the only person who saw the commission of the offense, PW3.
So where is the statement of the witness before the IO under section 161 CRPC? Is it with you?
It must be in the LCR, Lordship. It
Yes,
is not with me, Lordship.
LCR? Yes, Mr. Angami, the statement of the witness PW3, is it with you?
No, Lordship, one problem is we could not make the paper book, Lordship, that is.
Lordship, only 2 questions were asked during examination. None of the statements put by the prosecution witnesses.
No, that may be a case for remanding the matter to the trial court.
Yes, Lordship, that is what,
Maybe a ground, but
which is why, Lordship, my humble prayer is that the matter may be remanded, Lordship, to the trial court. So that, Lordship, and I may also be given the opportunity to recall witnesses, Lordship.
no, that order cannot be passed.
Because, Lordship, I have some rulings
So,
from the
at
apex
this,
court.
it says, we will not allow you to fill up the lacuna.
No,
We can remand the matter,
yes,
to put all the incriminating materials to him as per section 313 CRPC. But we will not give you the chance to fill up the lacuna.
Now,
What
Lordship,
ground?
because Lordship, important material issues,
Hmm.
material facts,
Hmm.
relevant facts needs to be settled, Lordship. Because Lordship, particularly identity part, Lordship.
Identity,
forget about-
you already got the opportunity there. You failed to establish it or
No,
failed to
Lordship,
negate it.
it is the prosecution's case, not my case, Lordship.
No, that's all right. That's all right. That's why I'm asking
If it was a
you.
single case, Lordship, that
No,
I
you
would
also
not
could
do
have
such
pointed
things,
out that whether that person is the person whom you have seen on the date of occurrence on that day.
yes,
Did you put such question to him?
that is why, Lordship.
No, now you cannot.
Now, which is why
No,
he
no,
has,
no, no,
he
no.
has stated, Lordship, he has stated that the accused is not the one whom we saw on that particular morning.
Now you
That-
cannot.
That question was specifically put to him, Lordship, during cross-examination.
So where is the case diary? This is not the case diary.
Now, Lordship, why I am saying this is because if the wrong person has been tried, if the wrong person has been convicted,
Hmm.
then Lordship, because of that, he has lost his job. Because he is facing on the trial court judgment case, his service has already been terminated.
Not the case diary.
Yes, yeah, they are the 50% magistrate. On the earlier date, my lord was gracious enough to grant me the liberty to peruse the.
Yes, have you gone through it?
Yes,
You have found the 161 statement.
I don't recollect, Lordship. I was more focused on the depositions of the prosecution witnesses. And the examination of the accused.
Mr. Angami, whether the court below used to transmit the case diary to the court, to the appellate court?
Yes.
But here we have not found it.
Yeah, I saw yesterday also. Because I perused only yesterday, Lordship.
You have produced
Yes.
161 statement.
Not 161 statement, Lordship.
No, those statement recorded by police at the time of
Yes,
investigation.
Lordship, yes.
Is there any file along with this?
No.
Not available.
Lordship, I may be allowed to place some judgment, Lordship. And Lordship, if
But,
even the Caesar, Lordship, the Caesar,
mm,
it's not proper, Lordship. Insofar as Lordship, the list of items is listed on a plain paper, Lordship. There is no signature, nothing, Lordship. It's just a simple piece of paper.
mm,
None of the accused witnesses have appended the signature.
mm.
If my memory serves right, Lordship, even the signature of the police officer is not there, Lordship. No seal. It's just a simple piece of paper like this. Now, only two questions were asked to him. He has explained the circumstances, Lordship. He slept, Lordship. PW2, Lordship.
Oh,
The accused. He slept PW because he was coming back from the push joint, the drinking, Lordship. Now, when going to the market, the PW2 and 3, they were already there. And they asked for his match. So they lit up a fire, they sat together. And when he was about to leave, the PW3 said that, no, you have stolen something. So, and began to check his pocket, Lordship. So he slept.
no, therefore, I want to see the statement of the PW3 before the IO,
My lord.
but that is not available now. What to do? Can we call for it from the court below?
My lord.
Yes, Mr. Angami.
Lordship, and if that is called, then the lower court records from the appellate court, that is the sessions court, is also not received, not before this court. So if that can also be called,
Yes. That
Because-
was not called for.
that is not here, Lordship. Because Lordship, after he was convicted by the trial court, an appeal was preferred before the appellate court.
Mm.
That file is not there, Lordship. That appeal was dismissed, Lordship.
No, then how the matter becomes ready for argument?
It was recorded in the notice that LCR has been received by this court. So I was under the impression that the appellate court's record are also here. But I only discovered yesterday that it's not here. And Lordship, before the appellate court, Lordship, while conducting hearing, I had received CTC of the lower court orders and trial court orders, original court orders. There was no Caesar memo. So I raised the objection that there is no Caesar. So on that ground, and on that day, Lordship, the public prosecutor was unable to produce the Caesar memo, Lordship, the property search and Caesar form.
Thereafter,
Thereafter, it was adjourned to another day, Lordship. Otherwise, Lordship, I was very confident that the appeal will be allowed. And just because of that simple question, it was adjourned. Now, a new sessions judge came, and the matter was heard at length. But Lordship, my submissions were not properly recorded, and the decided cases that I have placed, Lordship, they were not reflected in the order, and some decisions, Lordship, which I have not referred to at all. They were placed in the reproducing the judgment and order. I don't know how. Maybe he.
Lordship, my letter friend has submitted written submission.
Yes, that's what.
He says that, he has not case submitted list of the case, but the written submission is there.
No, yes, he is.
Yeah.
My letter friend is misunderstanding me, Lordship. What I'm saying is the.
My letter friend says that, he want, page 94, he did not submit borrowed by cases, but it is written submission is there, even the gist of the point he cited. So I don't think that is, now,
Well,
that amounts to misleading of the court, though. I'm not insisting that page 14. So, of course, that is concerned for clarification.
I have not blessed you.
Okay, then let the record come
Yes.
Lordship.
Lordship, in that
along
case-
with the case diary.
Yes. Lordship, in that case, I think, what about preparing paper book, so that it will be more easier, instead of flipping everything.
No, this is a paper books are usually prepared in case of type 1 session cases. In case of murder and other serious offenses.
Well, Lordship, the fact remains that Lordship 313 was not properly conducted. 313 is already before this honorable court, Lordship.
No, that is there. That is there.
Yes, so if Lordship, because on the next date also, I'll be praying only for remanding the matter to the trial court, Lordship. So if that can be done
No,
today as well, Lordship.
We'll see. We will finally dispose of the matter. Let the records come.
Lordship.
We will see the 161 statement. What this PW3 has stated before the IO during examination under section 161 CRPC.
Lordship.
Huh?
Lordship.
If we could finally dispose of the matter on that day, okay, well and good. Otherwise, we will remand the matter for proper examination of the accused under section 313
Yes,
CRPC
Lordship.
by putting all the incriminating materials.
And if that is done, Lordship, I may be also granted the
No.
liberty, Lordship.
No, that cannot be, that cannot. You will not be allowed to fill up the lacuna.
Because Lordship, the identity, Lordship, it goes to the core of the matter, Lordship. That is
That's
the
all right,
issue,
but
yes. If a wrong
you
person.
have already got the chance. But you fail to avail the same.
Lordship, if that is not properly settled, Lordship, then Lordship, it would amount to a travesty of justice, because somebody who is innocent, Lordship, he
That
cannot
is
be,
there, but
he cannot be.
that is there. But the thing is that you have been caught red-handed as per the.
No, Lordship, that is not so, Lordship.
The-
Because
the-
Lordship, see, the other day also, Lordship, I made a submission, Lordship, that, that submission, Lordship, off the record, I made a statement that in Nagaland, Lordship, it is unfortunate and a very sorry state of affairs that the police and the
No,
such
yeah.
connivance is there, Lordship.
So
So now, Lordship,
it is not only Nagaland, it is everywhere.
yes, Lordship.
It is
Now-
everywhere.
Now, Lordship, somebody else, Lordship. Who the police released, saying that no ground is made out against that person, Lordship. I believe, Lordship, that it is that other person whom the police have released, saying that there is no case to be proceeded against him, the next day. That is the person who has committed the offense, Lordship.
Who
And
was
I have
released?
been,
Who was released by police?
At first, the convict had stated that he has a companion. Then that the other person go for Levi. And he, the accused, I mean, the convict retracted that he was alone. Chain
It
of
was-
evidence, everything is interconnected.
it was not a plea of alibi, Lordship, because the police themselves, Lordship, without even filing charge sheet or without even proceeding against the person, Lordship.
Maybe.
And Lordship, which is why I am saying that Lordship, proper investigation has not been conducted.
No, to examine that, we won the case, I think.
Which is why, Lordship, which is why recalling of witnesses is essential, because even that person may be recalled, Lordship. Not recalled, maybe called, maybe summoned.
He could have brought him as his defense witness even before the trial court.
But the issue is, Lordship, whether a travesty of justice, Lordship, occurs or not, that is the issue, Lordship. And because of this, Lordship, my service has been terminated. Now, my two sons, my wife, Lordship, I am unable to support.
That is why now his health become thin. When he was in service, he was also healthy, possibly.
No.
Anyway, Lordship, since our now submission may be just more of a waste of time.
It's a case of shorty, casual, and where is highly suspicious investigation being conducted, Lordship.
That's all right. Let the city come and the record of the appellate court come. We will examine the matter.
Lordship.
Heard Mr. Santi Iyengar, learned counsel for the petitioner, then Mr. K. Angami, learned additional PP. No, sorry, learned PP for the state respondent. After hearing learned counsel for the petitioner at length, it has come to the notice of the court that a record of learned appellate court has not been received, being criminal appeal number 06 of 2014 in arising out of GR case number 14 of 2011. And further, it has come to the notice of the court that the case diary of GR case number 14 of 2011 is 11 arising out of KMA, which will get SBS case numbers 5 of 2011 is also not available in the record of the learned court of Chief Judicial Magistrate, Kohima. Accordingly, it is provided that registrar shall call for the case diary from the Court of Learned Chief Judicial Magistrate, Kohima, and the record of criminal appeal number 6 of 2014 arising out of GR case number 14 of 2011 from the Court of Learned Principal Session Judge, Kohima, Nagaland. List the matter after.
As per my lord's convenience, as the convenience of my learned friend.
Maybe 3 weeks ago.
After 3 weeks.
Yes, because we have to call for the report.
Yes,
My lord.
after 3 weeks. But in that case, we have to release the matter from part.
It's fine.
Pardon?
If my lords will come back in the near future.
No, I don't know. That is the prerogative of Chief Justice. I cannot say that I will come and hear the matter.
Yes. Then in that case, Lordship, I believe it would be better to,
Release it.
yes, Lordship,
Yes.
not keep it as part heard.
Okay. Release the matter from part.
Keep your plan.
So, Mr. Santianger, you can keep this with you,
Yes,
this
Lordship.
document. And you see the case law relating to this remanding of matter to the trial court
Yes.
for perfunctory examination under section 313.
Yes, Lordship.
Some authorities are there.
Yes, and in fact, for the
Acha,
book, yes.
acha. Okay.
But since we are not going into those, Lordship. Keep your pledge, my lord.
For hearing item number 23.
Yes, my lord. My lord, here, my case is that the petitioner who was serving as secretary of under establishment of Nagaland Civil Secretary, my lord, expired on 18/4/2014, my lord. And after the death of the petitioner father, the petitioner applied for appointment on compassionate ground. Well, before that, I would like to tell you about Annexure 1, where the state respondent has formulated the policy,
Page number?
page number 15, type copy is annex, page 16, my lord. Married, my lord.
Yes.
Yes, Government of Nagaland Personal and Administrative Reforms Department, Administrative Reforms Branch Office Memorandum, dated 17/9/2015, and 11/14 is a close to my lord. Appointment on compassionate ground shall be made only on a regular basis to direct recruitment posts, and only if regular vacancies meant for that purpose are available in that department where the deceased government employees were serving. Applicants shall have no claims of appointment under this scheme in any other department other than the department where the department employee was serving. However, for the NCS appointment may be considered under the subdivision of Commissioner Nagaland or the Nagaland Civil Secretary, my lord. So this is OM formulated by the state policy to give offer employment to the person who
When the father of the petitioner suffered demise,
18/4/2014, my lord.
2014.
Yes, my lord. My lord,
So this office memorandum was issued in 2015.
yes, my lord. This the earlier one and the present one, is all the same. Where it is OM, they have added 1 point. They have added 1 point. That is 4, my lord. Where in the earlier OM, here, my lord, my lord, compassionate appointment may be made to the post falling under the
Group C and group C or D.
Group C or D, the ceiling, my lord. Earlier it was 5% only, but
Yes.
by this OM, it has increased to 50% in a year, my lord. In a calendar year. So that is the only difference. My lord, as well as OM, right after, immediately after the expiry of my father, I applied for appointment on compassionate ground.
Where is the memorandum? Oh no, where is the representation?
Representation is at Annexure C, page number 19, my lord.
Page number
19, my lord.
19.
Yes, my lord. May I read this?
Not necessary.
Yes, as I applied for appointment on compassionate ground, my lord, the state respondent is appointed me on 13/05/2015, my lord.
So where is the date of this application?
My lord, here there is no tune, my lord.
Then how can we come to a conclusion that immediately after the death of your father, you have filed the application?
Yes, my lord, as I'm the eldest in the family, and my family is dependent on the income of my father. So immediately after the expiry of my father, I applied for it.
Where is the proof that you have submitted it to the authority, to the secretary?
My lord, appointment order has been issued, my lord. That is my,
After this,
I was appointed.
so you were appointed.
Yes, I was appointed.
Thereafter,
Thereafter, I was terminated.
Why?
After serving for 1 year. On the ground that the state respondent has not given approval.
Pardon?
That is, the state respondent has not, given approval, my lord. May I take-
And
then,
after 1 year,
After we won.
whether you have been given the salary for that period,
Yes, my lord.
you got it. And thereafter you have been terminated.
Yes. May I
What
take-
is the ground? Where is that letter?
That order is annexure E, my lord. Annexure E is 21. Type copy is at page 22, my lord. Married, my lord.
Hmm.
Government of Nagaland, Home Department, Secretary Administrative Branch Order, dated 12 May 2016, number 20. The re-designation employee was of personnel beyond as office beyond issued wide order number so-and-so, and the subsequent appointment of the foreign person as office beyond against those issued wide order dated wide order number so-and-so, dated so-and-so, were all found to be done without the approval of the government. So, here, the petitioner is number 2, the Menozono, and along with the petitioner, 10 others were also terminated from the service along with the petitioner. So here, my lord.
This type copy of this order is at page number
22, my lord.
22 or 24?
22, my lord.
No, 22 is another representation for reappointment. Yeah, 24 is that order.
Here, my petition is a mistake in petition. My lord, here the first copy is wrongly written. Find that there's a second copy. Your lordship, can you for the second copy?
No. So what is the requirement of obtaining approval from this PNR department? Is there any rule?
No, my lord, my learned counsel, the government will not be there.
Yes, madam?
We need the approval from the PNR lordship.
Pardon?
We need the approval lordship from the PNR lordship.
On what
Okay.
basis? Where is that document? Or where is that notification? Requiring to obtain approval from the PNR department. Pardon?
I don't have it with me right now, lordship, but I can place it up if sometime we be given lordship.
No, is there any notification to that effect or any order to that effect? That in case of compassionate appointment, approval has to be taken?
Yes, lordship, we need clearance lordship from the PNR lordship for every appointment lordship. For compassion.
That's all right. Where it is written?
Oh my God, and then the lordship to another order where two order has been issued by the department appointing the new appointees.
New?
Appointees.
Yes, where?
page 25, my lord.
Yes.
Annexes G, my lord. Here, my lord.
Yes,
the
November
order-
to
the order-
2017.
Yes, the order passed in this annexure G and the order where the additional orders appointed are the same, my lord. So first I'll take your lordship to annexure D, where the additional was appointed. my lord. Married, my lord. Annexure D, page 50.
Yes,
Order dated 13/0 May 2015, number so subsequent upon redesignation of 11 posts of personnel beyond created white department dated so and so, that of office beyond white border so and so, dated 12/3/2016. The following persons are hereby appointed regular office beyond in Nagaland, civil secretary Nagaland, in the revised pay scale of rupees so and so, with grade pay of rupees so and so, plus all other allowances as are admissible under rules from time to time, with effect from 1/6/2015. And Paratumanot, the above appointment is made under the terms and conditions as laid down in the new defined pensions scheme notified while finance department notification so and so, dated so and so. The regular retention in the service is subject to verification of character and medical fitness. So this is the order where the additional was appointed, and now your lordship, page 25, annexure C. Subsequent upon designation of 26 posts of personnel beyond created while this department order so and so, dated so and so, to the post of office beyond while this department ordered that of given number dated so and so, the following persons are hereby appointed as regular office beyond in the Nagaland Civil Secretary Kohima in the revised space so and so, the grade pay of this so and so, plus all other allowances as are admissible under the rules from them. So my lord, this order and then the order which the petitioner's appointment, it's all the same. There's no difference between here in this order. They have not stated that they have
approval is required.
approval has been granted. Nothing has been mentioned here. And
So,
also,
madam, you produce the document. Here, what is your pair to reappoint or to you are challenging this cancellation order?
my lord, here, my prayer is to reinstate in the service. in
So
terms of-
you have
in
not
terms-
challenged the legality of this cancellation order. Oh, yes, you have
Yes,
challenged it.
absolutely.
Yes, yes.
Lordship, the petitioner, when she was appointed, Lordship, she was not appointed on compassionate ground, Lordship. Initially, when she was appointed, Lordship. It was not on compassionate ground, Lordship.
Yes.
And she made a submission, she submitted her representation only in the year 2018, Lordship,
2018,
18.
when the appointment was made.
2015 month. I was
15.
appointed in 2015.
Initially, she was appointed in the year 2015. Then after a gap of 1 year, Lordship, she was terminated because there was no clearance from the PNR, Lordship, along with 10 others.
You produce the requirement. On next Tuesday, you produce it.
My lord, can you come up after some time? I think she will get it. It's in the one compilation, so I think she will get it from there.
From where?
There's one book where the PNAR department is compiled in a form of book. So there it should.
Is it available in the court?
Yeah. It will be. If possible, we can take up, otherwise we can go somewhere else.
Okay. But nowhere in the appointment letter, it has been mentioned that you have been appointed on compassionate ground.
Yes, my lord, there has not been, I was appointed along with others,
Yes.
then others. But after. When the appointment is, appointment order is issued, normally does the respondent don't mention that so and so person is appointed or.
Compassionate, no.
Or land ownership is just.
You produce that document then. Let's see. Yes, next item.
For hearing item number 24.
None appears for the petitioner on call. How about Miss? You are for the respondent,
Lordship,
Miss so and so, learned government advocate. Present for the state respondent, list the matter after 1 week.
right, Lordship.
For hearing item number 25.
Yes.
My lord, here the petitioner is a pensioner who retired in the year 2005.
Hmm.
So my lord, after his retirement, my lord, he has served as a registrar of this registry of the.
After retirement, his
So
service,
he served as a, he retired as a, like,
register of this court.
Yes.
Yes.
So my lord, after his retirement, my lord, a new ROP, he retired under ROP 99. After his retirement, the new ROP, that is ROP revision of the rule 2010. I know that was implemented. So my lord, I have reproduced the provision of the ROP rule as page 6 of my petition.
Page number 6
Page 6.
of your petition.
Yes, yes, upon the petition.
Yes.
Parachi, my lord, below, rule 19. that is
Pension.
pension.
Yes.
But bear it for Parachi, my lord.
Mhm.
That upon enforcement of the Nagaland Services Revision of Pay Rules 2010 to the petitioners of the state of Nagaland with effect from 01/04/2010, the petitioners entitled to the revised monthly pension of 50% corresponding to the revised pay scale from which the petitioner has retired. In terms of the provisions of Rule 19(1), Clause A, E, and subclause 5 of the Nagaland Services Division of Pay Rules 2010, hereinafter referred to as the ROP Rules 2010 in short. The relevant provisions of Rule 19 of the ROP Rules 2010 are abstracted here in the which is as follows. Rule 19, pension. Revised pension, family pension. Pension to be paid at 50% of the average emoluments last paid drawn, whichever is more beneficial, without thinking to 33 years of qualifying service for grant of full pension, provided the employee concerned has rendered a minimum pensionable service of 20 years. Now, my lord, clause E, the family pension, family pension of all existing pensioners, family pensioners, that is persons drawing pension, family pension as on 31/05/2008, shall be consolidated as on 1st June 2008. Next page, my lord. Subclause 5. The amount so arrived will be revised. Basic pension subject to the provision that the revised pension, family pension, in no case shall be lower than 50%, 30% of the sum of the minimum of pay in the pay band and the grade pay thereof, corresponding to the pre-revised pay scale from which the petitioner had retired or died. So my lord, on the basis of this rule, the petitioner provided the minimum 50% of basic. That is 24,000. So my lord, after the implementation of this ROP rule, another notification was issued by the government, right? OM dated 5th May 2017.
Page number?
Page number, at page 23, the typed copy is at annex 20, page 23, typed copy is at page 24. my lord. This is office memorandum dated 5th May 2017, issued by the government of Nagaland, Finance Department, Staff in the branch ROP cell. Subject, implementation of the decision of the government of India, revision of pension, family pension of pre-2008 pensioners, family pensions. So my lord, this covers the petitioner, because the petitioner retired in 2005, 5 February. So my lord, by this OM, the provision of Rule 19, Sub-Rule 1 was modified. Very well. The undersigned is directed to refer to the subject cited above and to convey the approval of the government of Nagaland to adopt the decision of the government of India in the following manner. Number 1, para 1, the existing provisions of under Sub-Rule 1 of Rule 19 of Nagaland Services ROP Rules 2010 is modified as follows. Roman 1, small 1, the pension, family pension of 3/16/2008 pensioners, family pensioners are revised with effect from 1/6/2008 in terms of Sub-Rule 1 of Rule 19 of Nagaland ROP Rules 2010 as notified by the Finance Department by number so and so dated 10/8/2010 as amended from time to time shall be further. This word is important, shall be further stepped up to 50%/30% as the case may be of the sum of minimum of pay in the pay band and the rate pay corresponding to the pre-revised pay scale from which the petitioner had retired as arrived at with reference to treatment tables annexed as Annex 3 to the Nagaland Services ROP Rules 2010, notified by Finance Department notification dated 10/8/2010 referred to above. Then Roman 2, my lord. The effective date for this modification shall be 1/6/2013. There shall be no change in the amount of revised pension, family pension paid during the period 1/6/2008 to 31/05/2013, and therefore no area will be payable on account of these orders for that period. Now, second paragraph, my lord. This office memorandum is issued with the clearance of PNR Department by UO number 42 dated 2 August 2013 and approval of the cabinet conveyed by letter number CAT 2/2013 dated 26/4/2017. So my lord, this has been issued upon clearance of the PNR Department and approval of the cabinet. So my lord,
As per this memorandum, you were entitled to drop 50% of the basic pay.
it is stepped up, my lord.
Yes.
It is stepped up to 50% of basic pay from which the petitioner paid, corresponding to the pay from which.
From which petitioner? From which the petitioner?
He retired at the maximum level, in the pay scale. So, my lord, as per this provision, he is entitled for the maximum scale only
Mm.
in the revised scale. But whereas the department paid only the minimum, 50% of the minimum scale.
Mm.
So my lord, then my lord, next page, that is page 25. Is another poem office memorandum, which is dated 20 December 2017, annexure C. My lord, the type
No,
of.
no, in this notification also, it is memorandum also, it is stated as the minimum of pay of the payment.
Shall be further stepped up,
Hmm.
my lord.
Shall we further step up to 50%?
As the case may be of the sum of minimum of pay.
Minimum of pay,
In the
payment,
payment, and the grade pay corresponding, my lord, this is important, my lord.
corresponding to
the
pre-revised,
pay,
yes.
pay scale from which the petitioner had retired
Hmm.
as arrived, my lord.
So here also it is stated to be the minimum pay of the payment.
So, my lord, here the pay scale starts from in respect of the petitioner.
Yes.
My
Where
lord,
you have mentioned it.
yes. I have annexed in my additional affidavit in reply, the annexure one.
Affidavit in reply.
Yes, my lord. Affidavit in reply to the affidavit in opposition of. Respondent one,
Hmm. Page number?
page number 11. Annexure R1.
Yes.
So, my lord, this is the table 20.
Hmm.
Table 20 is applicable for me, my lord. The basic pay start from 1600, 16,400 and up to 20,900. In the third, my lord, bearing, my lord. Daily recorder for fixation of pay under Nagaland Services Revision of Pay Rules 2010, table 20. Existing pay scale L20, that is starting from 16.
Yeah, you are reading this annexure R1.
My lord.
Hmm. Which part?
My lord, the first column,
Yes.
the first column starting from.
Basic pay in the existing pre-revised scale.
Yes.
And next is grade pay.
So, my lord, serial column 1
Hmm.
from 16,400,
Hmm.
the last, the apex pay is 20,900 in column 1.
Yes.
This is the existing say from which the.
Yes,
the tax,
20,900.
20,900.
Yes.
So, my lord, as per this table, I am entitled, which is a column 4, my lord. Last para, last issue. It is 54,600.
Hmm. Hmm.
My lord, I have represented to the authority for granting me this revision of the. My lord, at page 29, annexure B.
In your petition.
Yes, ma'am. Page 29, annexure B.
So now you are drawing the pension at the rate of rupees?
Now, my lord, it is a different ROP now. The ROP 2017.
Yes.
Yes. So there I am doing activities, my lord, the highest. But in respect of 2010 ROP, I have been denied.
Yes. Why?
Your Lordship, I'm sorry, I couldn't get the question, Your Lordship. If I may be allowed.
Yes,
My lord, I'll just clarify the position after approaching the authority.
Hmm.
My lord, what was the result outcome of my resignation? Your lordship,
your representation is at page number?
page number 29. Page number 29. I have
Yes.
applied for implementation of this OM dated 5/5/2017
Hmm.
to the principal accountant general.
Hmm.
So my lord, the reply to this is the next page, page 30, my lord.
Yes.
My lord, last para would be relevant for this, for my purpose. Here, the reply was that the office of the principal accountant general AE Nagaland is the pension authorizing agency and not the pension sanctioning authority. That was the reply. So on getting
Who
this
is the
reply,
pension sanctioning authority then?
that is the finance department.
Finance department.
So I have submitted
So
finance
thereafter, have you submitted any representation
yes.
to the?
Yes.
uh,
to the government.
Yes,
Yes, at
finance
page 31,
department. Page number?
31, and next F.
Yes.
So my lord, here, my subject is representation against erroneous fixation of revision of pension, family pension of pre-2008 pensioners, family pensioners by annexure 1 of the office memorandum dated 2012-2017. So, my lord, against this was addressed by the authority.
Whether you received any reply?
Yes, my lord.
Where?
Page 37, annexure P.
Yes, what is the
Yes, my lord,
contention?
it is 2nd March 2022.
Hmm.
This is by the finance department,
Hmm.
ROP cell.
Hmm.
This is addressed to the principal accountant general ANE Nagaland Kohima. Subject: representation against erroneous fixation of revision of pension, family pension of pre-2008 pensioners, family pensioners. Sir, copy of representation dated 2nd December 2021 from Sri Sai retired minister Gauhati Airport Kohima schedule. In this connection, it is stated that Table 20 of Annexure 3 to Government Services Revision of Pay Rules 2010 clearly exhibits the formula for fixation of pay in the state of pay band 37,400 to 67,000 with grade pay of rupees 9,900. As stipulated at Rule 8.2 of Nagaland Services Division of Pay Rules 2010 OP post, 2 additional increments at the rate of 3% have been granted to the minimum pay band at the time of initial fixation in respect of pay scale of 16,500 to 20,900, which is clearly reflected at column 3 of annexure 3 table 20. The revised basic pay along with progress of pay in the pay band is reflected at column 4 of the same annexure. Further, Finance Department OM of even number dated 5/8/2017 clearly states that pension has to be fixed with reference to annexure 3 of Nagaland Services, the revision of pay rules 2010, being closed. It is clear from para 2 of the representation dated 2nd December 2021 and PRAG AE letter number so dated 1st October 2021 that pension in respect of the retired officer has not been fixed in accordance with the table 20 of annexure 3 of Nagaland Services Revision of Pay Rules 2010. As such, it is requested that the pension in respect of the retired official be reviewed and refixed in accordance with table 20 of Annexure 3 of ROP 2010. So, my lord, thereafter, a reply was given by the AG, principal AG to the Finance Department, my lord, which is at the next page, page 38, Annexure 8. May I read, my lord? To the Commissioner, this is dated 9th June 2022. To the Commissioner and Secretary to the Government of Nagaland, Finance Department, establishing branch, ROP cell, Kohima, Nagaland, Kohima. Subject, revision of pension, family pension of 2008 pensioners as per ROP 2010 rate. Sir, in writing a reference to your letter number so dated 2nd March 2022 regarding revision of pension, family pension of pre-2008 pensioners, I have to state that the table number 20 of Annexure 3 of Nagaland Service Revision of Pay Rule 2010 exhibit the formula for fixation of pay in respect of pay band of 37,400 to 67,000 with grade pay of 9,900 and provision of Rule 8.2 of ROP Rule 2010 is related to the employee who retired on or after 1st June 2008 and not for the pre-2008 pensioners. The applicant retired on superannuation on 28 to 2005. A copy of the Annexure table 20 is enclosed for reference. As per the ROP notification dated 10/08/2010, para 19, pension 5, the revised pension, family pension in no case shall be lower than 50% of the sum of the minimum of the pay in the pay band and the grade pay. Therefore, corresponding to the pre-revised pay scale from which the petitioner had died. The pay scale of the pensioner at the time of retirement was 16,400 2019. The revised corresponding pay scale on the ROP 2010 is rupees so and so with grade P of rupees 9,900. Pension as per ROP 2010 should not be less than so and so, it is so and so, rupees so and so. Further, as for OM number so and so, dated 5/05/2017, it is clearly stated that the pension, family pension of pre-1/6/2008 pensioner, family pensioner as revised with effect from 1/6/2008 in terms of sub-rule 1 of Rule 19, Nagaland Services ROP 2010 as amended from time to time shall be further stepped up to 50%/30% as the case may be of the sum of minimum of pay in the pay band and grade pay corresponding to the pre-revised scale from which the petitioner had retired as arrived at with reference to finance treatment table Annexure 3 to the Nagaland Service ROP Rule 2010 notified by Finance Department notification dated 10/08/2010. This office has revised the pension of 3 entire register as per the review recorder, number 20 of Annexure 3 of Government of Nagaland, so and so, dated 5/5/2017 by this office authority number so and so for an amount of rupees 24,795 with effect from 1/6/2013. It is therefore requested to clarify how the provision of Annexure 3 of Nagaland Services Revision of Pay 2010 as indicated in the OM number so and so dated 05/05/2017 is applicable to pre-2008 pensioners, family pensioners with registration for settling pending cases. So, after this, the reply of the Finance Department in respect of the petitioner's case to the principal AG is at page 40, Annexure I. This is by the Finance Department, Government of Nagaland, ROP cell, dated 5th September 2022. To the Principal Accountant General, A&E, Nagaland, Kohima. Subject, revision of pension, family pension of pre-2008 pensioners as per ROP 2010. Sir, I am directed to refer to a letter number so and so dated 9 June 2022 on the subject cited above and to state that Sri Sai Rale, retired registrar, Gauhati, Kohima, has retired after reaching the apex basic pay in the pay scale. Therefore, his pension on implementation of ROP rules 2010 should be fit with reference to the corresponding pay and not with reference to the minimum of pay scale. Tomorrow, from the finance department is clarified that it has to be with reference to the corresponding pay scale from which he retired and not to the minimum pay.
As per this letter.
As per this letter, which
So
is based
this
on
is the letter of the finance department.
Yes.
Then what AG has done?
So my lords, IT has not implemented, so because of which
We are clear. Dated 8/12/2025. We are replying to the finance. Why it should not be there?
At page number?
Page number 11 of my share for one of the.
Paragraph number?
Possibly we can come to the annexure for page 11,
Annexer?
for page 11. Oh, the last time.
Annexer 4.
Letter dated 8/12/2025.
Yes.
This is in reference to the finance letter.
Hmm.
I will not read it.
Yes. Come this side.
Yes.
To the Additional Chief Secretary and Finance Commissioner, Government of Nagaland, Kohima, this is letter dated 8/12/2022. Subject, revision of pay, pension, family pension of pre-2008, Lordship, this is very important, of pre-2008 pensioners as per 6 ROP 2010 regarding. Sir, in inviting a reference to finance letter dated number so and so dated 5/9/2022, Lordship, which my learned friend has just relied upon, the finance letter. Regarding revision of pension in respect of Sri Shari Reling, retired registrar Gauhati High Court, Kohima Bench, who retired on 28/2/2005. I am to inform you that the office had already authorized revised pension of Sri so-and-so as per Government of Nagaland notification number so-and-so dated 16/12/2017. No separate notification order regarding fixation of pension on reaching apex basic pay has been received by this office from the state government. The pensioner is, in this case, is claiming his pay should be fixed first as per 6 ROP table number 20 of the 6 ROP notification, which is applicable only for pay fixation for existing employee who were in service as on 6/1/6/2008. Lordship, this is important. Pre and after. Firstly, I'm to state that the table 20 of the annexure 3 of the Nagaland Service Revision of Pay Rules 2010 exhibits the formula of fixation of pay in respect of pay band of 37,400 to 67,000 with grade pay of 9,900 and provision of Rule 8 Clause 2 of the ROP Rule 2010 is related to employees who retired on or after 1/6/2008. A copy of the table annexure table 20 is enclosed for reference. So this table 20 is applicable only for those who have retired on 1/6/2008 and after, not pre. The case of the petitioner is retired in 2005. He is claiming the ROP of 2010, which came in force in 1/6/2008.
That's why.
Yes, he's already retired. The fixation will count only for those who are in service as on 1/6/2008 and after. As per ROP notification dated 10/8/2010, para 19, pension clause 5, the revised pension, family pension in no case shall be lower than 50%, 30% of the sum of the minimum of the pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scale from which the pensioner died. The pay scale of the pensioner at the time of retirement with effect retirement was 16,400 so. The revised corresponding pay scale under ROP 2010 is 37,490 with grade pay of 9,900. Pension as per ROP 2010 should not be less than so-and-so amount. Further, as per OM number so-and-so dated 5/7/2017, it is clearly stated that the pension, family pension of pre-1/6/2008 family pensioners are revised with effect from 1/6/2008. This is important again, Lordship. in terms of the sub-rule 1 of the Rule 19, Nagaland Services ROP Rule 2010, as amended from time to time, shall be further stepped up to 50 to 30% as the case may be, of the sum of minimum of pay in the pay band and grade pay corresponding to the pre-revised pay scale from which the pensioner had retired as arrived at with reference to the fitment table Annexure 3 to the Nagaland Services ROP Rules 2010, notified by finance notification dated 10/8/2010. Now the clarification given, Lordship. This office has revised the pension of Sri so-and-so, retired registrar, as per the ready reckoner serial number 20 of the table 3 of the Government of Nagaland OM number so-and-so dated 5/5/2017 by this office authority number so-and-so dated 18/4/2018 for an amount of rupees 24,795 with effect from 1/6/2013. As for 7 ROP, his basic pension is rupees 62,723 with effect from 1/1/2018. It is therefore requested to clarify how the pension provisions of Annexure 3 of the Nagaland Services Revision of Pay Rule 2010 as indicated in OM number so-and-so dated 5/5/2017 is applicable to pre-2008 pensioner, family pensioner. It may be mentioned here that if pension is revised as claimed by the pensioner, it will be applicable to all other government state pensioner which will have a huge financial burden on the state government for payment of pension and arrear pension. So the issue of pre-1/6/2008, Lordship. The fixation comes to play from 1/6/2008 and who have retired after that, not to pre. The case of the petitioner is retired in 2005. So under the rules, Lordship, our objection is, how can we give the fixation of 2000 ROP 2010 when he is already retired in 2005? So we have given justification. In fact, the OM issued by the state government, Lordship, is very clear, which my learned friend will be relying on it later, Lordship, because there is a government notification. 2017 is very clear. Just to supplement that part, Lordship, since the state is.
Lordship, before I give my submission, just for clarification with regard to this, Your Lordship, in my paragraph, in my affidavit in opposition on behalf of 1 and 2, Your Lordship, paragraph 7, Your Lordship, page 3, Your Lordship, of my affidavit in opposition, Your Lordship.
Paragraph number?
Paragraph number 7, page 3, Your Lordship.
Yes.
On this issue, Your Lordship, if I may be allowed to read, Your Lordship.
Yes, yes.
That regard with the statement made in paragraph 7 and 8 of the writ petition, the answering department states that the case was re-examined by the finance department and states that table 20 of Annexure 3 relates to fixation of pay notionally with effect from 1/6/2008 in respect of serving employees. The petitioner retired in February 2005 and hence he is entitled only to fixation of pension at 50% of the minimum of pay in the pay band and grade with reference to table such and such under ROP such and such. Accordingly, the matter was clarified to the AG Nagaland by such and such letter. Your Lordship, if I may be allowed to read the Annexure A, Your Lordship, clarification was made through this, Your Lordship. Annexure A, page 5, Your Lordship, of my affidavit, Your Lordship. I may be allowed to read, Your Lordship. To the Principal Accountant General such and such, subject revision of pension, family pension such and such. Sir, I am directed to refer to a letter such and such on the subject cited above and to state that revision of pension of Sri such and such has been reviewed. Finance Department OM such and such stipulates that pension should be stepped up to 50% of the minimum of pay in the pay band and the grade pay with reference to annexure such and such. Based on this, the pension of the retired official has been stepped up from rupees 23650 to 24795 by your office. Hence, the pension fixed by your office is in accordance with extant orders. However, the effective date of the implementation of the revised pension should be with effect from 1/4/2010 instead of 1/6/2013 in accordance with the Finance Department. So, Your Lordship, we're saying that whatever the AG has, the pension fixation made by the AG is correct, Your Lordship, through this order, Your Lordship. I mean, through this letter, Your Lordship. And Your Lordship, I may be allowed to submit, Your Lordship. Your Lordship, here the table 20 annexure X, Your Lordship.
Annexure?
Your Lordship, they have also annexed in the red petition, but for easy reference, Your Lordship. Your Lordship, I'll refer to that later, but Your Lordship, the petitioner retired in the year 2005, Your Lordship. Therefore, the ROP 2010 is not applicable to them. However, the government through OEM dated 5/5/2017 and 20/12/2017, which is annexure B and C in the writ petition, Your Lordship. Through this OEM, Your Lordship, the government gave some financial benefit in the form of pension revision, Your Lordship. Not pay fixation, pension revision to pre-2008 pensioner, Your Lordship. And Your Lordship, if you may turn to the writ petition, page number. Annexure C, Your Lordship. This might be important to go through the OEM, Your Lordship. Page number 25. Annexure C, Your Lordship.
Yes.
Implementation of the decision of the government of India a revision of family pension of pre-2008 pensioner, family pensioner. Preference such and such. The undersigned is directed to refer to the subject cited above and to modify the OEM number such and such in the following manner. The date of implementation for revision of the pensioner family pension shall be effective from 1/4/2010. That is the date of implementation of the ROP 2010 and not as mentioned in the said office memorandum. The amendment is carried out in line with OM issued by the government of India such and such dated 3/7/2015. All other conditions mentioned in earlier OM even number dated 5/5/2017 remain unchanged. A ready reckoner indicating minimum pension, family pension of pre-1/6/2008 pensioners, family pensioners for post-caring corresponding to pay band and grade pay is indicated at Annexure 1, Your Lordship. Annexure 1 is at page 26, Your Lordship. And serial number 20, Your Lordship. This is the grade pay at which the petitioner retired, Your Lordship. And serial number 20. So 16,400, 500, 2,900. This is the grade pay on which the petitioner.
Serial number 20.
Yes, serial number 20. And the pay band is 4. And the corresponding pay band under the Nagaland, this is the revision of the corresponding pay, Your Lordship. Under serial number 3, the 3,700, 6,700, which is also indicated in that table which I have submitted, Your Lordship. And Your Lordship, this is the table number 4, Your Lordship. Sum of minimum of pay in the pay band and grade pay as on 1/6/2008 as per fitment table given at Annexure 3 to Nagaland Service Revision ROP 2010, Your Lordship. In the same line, Your Lordship, serial number 20, 49550, Your Lordship. This is the minimum of pay, Your Lordship, after revision of pension, Your Lordship. And the next column, Your Lordship, 5. Under column number 5, 24795, Your Lordship. So through this OEM note, it's very specific, Your Lordship. The petitioner is entitled to get this amount, Your Lordship, 24795, which has already been given to the petitioner, Your Lordship. 24795, Your Lordship. And they have also admitted, Your Lordship. So, Your Lordship, the ROP 2010 is for fixation of pay, Your Lordship. But through an OEM, Lordship, some financial benefit was given in the form of pension revision, Your Lordship. And this OEM clearly states that it has to be the 50% of sum of minimum of pay, Your Lordship. The sum of minimum of pay which the petitioner was getting was 16,400, Your Lordship. And if you go through the OEM, that ROP, Your Lordship, table 20, Your Lordship, Annexure 3, Your Lordship.
Annexure?
Your Lordship, Annexure 3, I've marked, flagged in the ROP book, Your Lordship, which I've submitted right now.
Yes.
Table 20, Your Lordship.
Yes.
So existing scale pay is 16,400, 500, 2,900. And revised pay band is 3,700 6,700, Your Lordship. And then in the column here, Your Lordship, first column, Your Lordship, 16,400, Your Lordship.
Yes.
Maybe got it, Your Lordship. And in the same line, Your Lordship, under notional revised basic pay as on 1/6/2008, Your Lordship. This is 49590. This is exactly the same in the reckoner table, which I've just shown, Your Lordship. So accordingly, Your Lordship, according to this table and according to this ready reckoner, Lordship, the petitioner has already been, his pension has already been fixed, Your Lordship. So there's nothing left to be adjudicated, Your Lordship. That's my submission, Your Lordship.
My lord, it is very interesting on the part of the respective authorities. In one way, and they said that ROP 2010 is not applicable in respect of the petition. Whereas the office memorandum dated 5/5/2017, that has been issued in respect of pre-2008 retirees, 2008 pensioners. So I'm only in that. I'm covered by that OMR. Since I retired prior to 2008. And this OM has been adopted by the state government, taking the decision, adopting the decision of the central government. Whereby pre-pensioners of 2008 pensioners, family pensioners, they are included entitled for the ROP 2010. It is clear, my lord. This has been modified. The first Roman 1, annexure B, the pension, family pension of pre-2000.
Annexure D.
Annexure B, my lord. B, page 23.
Yes.
Rule 19, sub-rule 1 has been modified, my lord, in this manner. Roman 1. The pension, family pension of pre-1/6/2008 pensioners. Family pensioners as revised with effect from 1/6/2008 in terms of sub-rule 1 of Rule 19 of Nagaland Services ROP Rules 2010 as notified by the Finance Department by so and so dated 10/8/2010. About 10/8/2010, this is notification in respect of ROP 2010. As amended from time to time, some is stepped up to 50%, 30% as the case may be, of the sum of minimum of pay in the parent. My lord, if it is minimum of pay of the parent, then they will be right to fix it in the minimum of the state. But here, it is in the parent. My lord, this is the meaning is also important, my lord. If it is of the parent, then they will be right. But here the word is very clear, it is in the parent. Starting from 16,400, it reaches up to 20,000 in that payment. And matter further, and the grade pay corresponding to the pre-revised pay scale from which the petitioner has retired, as arrived at with reference to fitment tables annexure 3. Annexure 3 to the Nagaland Services ROP 2000. My lord, that is the annexure. There is no other annexure, my lord. The annexure which has been placed before lordship. Annexure 3, that is the annexure. In payment as petty, it starts from 16,400 and it reaches up to 20,009. So my client, the petitioner retired at the apex scale, 20,009. So as per this notification manual, which has the clearance of the PNR, approval of the cabinet. Now, how can they say that since I retired in 2005, I'm not entitled? Whereas the poem is very clear. It is for 2008 retirees. 2008 pensioner, family pensioner.
That's why we've.
Along with.
Let him come.
Yes. And because of this election which has been annexed, election one in OIL dated 20 December 2017, election C minor, which is at page 26 of my petition. Against these anomalies, I have given those by petition and election F page 31. Here I have exhaustively elaborately discussed that there is the fixation is erroneous. And basing on that representation, they accepted my position. Yes, I retired, but the facts came up. That is 20,009. And whereas my pension revised pension has been fixed at 16,004. May I read my Mr. Manor?
Which one? Which one?
Manor, page 31, annexure F. Para 1, Manor, annexure F, para 1, number 1. Yes, sir, annexure 1 of the office memorandum number 22, dated 2012-2017, which is the table showing the amount of minimum amount of pension, family pension and ordinary rates of pre-2008 pensioners, family pensioners for the post getting corresponding pay band and grade pay under the Nagaland Services Rules 2010 is erroneous and cannot be applied in my case for the following reasons. Next page, I have given the reasons. A. Page 22, A.
Got it.
That the government of India, Ministry of Personal Public Grievances and Pensions, Department of Pension and Pensioners Welfare, 5 number, so it was dated 29/08/2008, broadly accepted the implementation of the 6th Central Pay Commission with certain modification of item number 12. The contents of item number 12 of the resolution dated 29/08/2008 is extracted together, which is as follows. Serial number column, first column. Well, all past pensioners should be allowed benefit equal to 40% of the pension, excluding the effect of merger of 50% generous allowance, generous relief as pension, with respect of pensioners retiring on or after 1/4/2004, and generous pension for other pensioners respectively. The increase will be allowed by subsuming the effect of conversion of 50% of generous relief, generous allowance, generous pension, generous pay. Consequently, generous relief at the rate of 74% on pension, excluding the effect of merger, has been taken for the purpose of computing revised pension as 1/1/2006. This is consistent with the treatment benefit being allowed in the case of the existing employee. The fixation of pension will be subject to provisions that the revised pension in no case shall be more than 50% of the sum of the minimum of the pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scale from which pension has retired. But my lord, this was the competition of the Central Pay Commission. The decision of the government is the next column, my lord. Column 3. Accepted with the modification that fixation of pension shall be based on a multiplication factor of 1.86, that is the sick pension plus generous pension, whichever applicable, plus generous relief of 24% as on 1/6/2006 instead of 1.74. Next para B. That the government of India, Ministry of Personal Public Grievances and Pensions, Department of Pension and Pensions Welfare, by office memorandum number dated 1/9/2008, communicated the decision of the government and sanction of the president. In para 4.2 of said OIL dated 01/09/2008, it is provided that the fixation of pension will be subject to the provision that the revised pension in no case shall be lower than 50% of the minimum of the pay in the payment plus grade pay corresponding to the pre-revised pay scale from which the pensioner has retired. Similarly, Rule 91E5 of the Nagaland Services ROP Rules 2010 provides as follows. The amount so arrived with the revised basic pension, subject to the provision that the revised pension, family pension in no case shall be lower than 50%/30% of the sum of minimum of pay in the pay band and the grade pay level corresponding to the pre-revised pay scale from which the pensioner has retired or died. C, that the government of India, Ministry of Personal Public Pensions and Pensions, Department of Pension and Pensioners Welfare, by Office Memorandum number so and so, dated 37/2015, decided to comply with the resolution dated 29/08/2008 and OM dated 19/2008 in view of the judicial pronouncement. D, that the government of Nagaland has also adopted the decision of the government of India dated 30/07/2015 by modifying sub-rule 1 of Rule 19 of the Nagaland Services ROP Rules 2010 by OM dated 5/5/2017. In the same OM dated 5/5/2017, the ready to corner relating to the revised pension, family pension has arrived with reference to the fitment tables annexed as annexation to the Nagaland Services ROP Rules 2010. The content of the OM dated so and so is accepted here under which is as follows. So, my lord, this is the content of the OM, which I want to refer earlier. Now, my lord, next page. Para E, my lord. That the fitment table 20 of Annex 3 of the Nagaland Services ROP Rules 2010 in respect of the pre-revised pay scale S20 16/400-500-29,900 has been revised to pay band PB4 37,467,000 with grade pay rupees 9,900. As formulated in the fitment table 20, the pay band varies from basic pay to basic pay, whereas the grade pay is fixed. Thus, column 4 of the fitment table 20 of Annex 3 provides pay in the pay band and the grade pay without increment as on 1/6/2008, and it's 50%/30% as revised pension, family pension corresponding to pre-revised pay scale from which the petitioner has retired as arrived at with reference to the fitment table annexes Annex 3 to the Nagaland Services ROP Rules 2010 notified by Finance Department notification dated 10/8/2010. The fitment table 20 of Annex 3 serial number 1 to serial number 10 formulated the details of pre-revised minimum basic and pre-revised maximum basic pay in the revised pay band and grade. Para F.
Okay,
Yes.
it is 1 o'clock now. So we will start at 2 p.m.
that these games happen.
Olympic Association. Remarkable blood. And we give a huge shout to the president of remarkable blood.
I'd like to spend our not
So cultivated and marvelous.
Ah. You what? 7. Alright. Huh? Alright.
Yes.
Yes, my lord. Not coming back to my annexure F page 31. My lord. At page 35. My lord.
Yes.
F.
So this is a representation
Yes, my lord.
submitted by the petition
Yes,
to the,
so yes, to the finance department.
yes.
So my lord. Next annexure, that is the reply of the finance department.
Hmm.
The finance department is attended to my, addressed to my representation. My lord, here, the finance department is clarified that yes, it has to be revised. Where, my lord, page 37, annexure G, my lord. Dated 2nd March 2022. May I get, my lord? Representation against erroneous fixation of division of pension, family pension of pre-2008 pensioners, family pensioners. Sir, para one, copy of representation dated 2nd December 2021 from Sai retired registered Gauhati High Court, Kohima bench is proceeded. Para two, it is connected. It is stated that table 20 of annexure 3 to Nagaland services, division of pay books 2010 clearly exhibits the formula for fixation of pay in respect of payment 37,467,000 rupees 9,900. As stipulated at Rule 8 of Nagaland Services Revision of Pay Rules 2010, of includes 2 additional increments at the rate of 3% have been granted to the minimum pay band at the time of initial fixation in respect of pay scale of rupees 16,400 dash 500 dash 20,900, which is clearly reflected at column 3 of annexure 3 table 20. The revised basic pay along with progress of pay in the pay band is reflected at column number 4 of the same annexure. Further, para 3, further finance department OM of event number dated 5/8/2017 clearly states that pension has to be fixed with reference to annexure 3 of Nagaland Services Revision of Pay Rules 2010 copy enclosed. Para 4, it is clear for para 2 of the registration dated 2nd December 2021 and Principal AE letter dated 1st October 2021 that pension in respect of the retired official has not been fixed in accordance with table 20 of Annex 3 of Nagaland Services Revision of Pay Rules 2010. As such, it is requested that pension in respect of the retired official be reviewed and refixed in accordance with table 20 of Annex 3 of ROP Rules 2010. Oh my God.
Madam, yes, this is your letter.
Yes, we have clarified in our affidavit, Your Lordship, with the annexure A, page 5, which I've already read earlier, Your Lordship, stating that whatever the AG has fixed, it's according to the extant orders, Your Lordship. Because the AG is the authority for fixation of pay and pension, Your Lordship. The date 21st February 2023, Your Lordship, annexure A of my affidavit, Your Lordship.
So are they supposed, letters are not contradictory to each other?
Your Lordship.
There's a letter dated 2nd of March 2022 and 21st February 2023.
Yes, Your Lordship, I've made a categorical statement at para 7, Your Lordship, saying that the issue has been re-examined, Your Lordship, in 7, Your Lordship, if I may be allowed to read, Your Lordship.
Para
But-
7.
Yes, Your Lordship. That with regard to the statement made in paragraph 7 and 8 of the writ petition, the answering deponent states that the case was re-examined by the finance department and states that table 20 of annexure 3 relates to fixation of pay notionally with effect from 1/6/2008 in respect of serving employees. The petitioner retired in February 2005 and hence he is entitled to only fixation of pension at 50% of the minimum of pay in the pay band and grade pay with reference to table 20 and annexure 3 under ROP rules 2010. Accordingly, the matter was clarified to Principal AG Nagaland by letters such and such. This is the letter, Your Lordship. And Your Lordship, the OM is also very clear, Your Lordship. It says minimum of the pay, Your Lordship. Nowhere it said maximum of the pay, Your Lordship. It's minimum of the pay, Your Lordship. And accordingly, this, as per this OM, Your Lordship, the AG has had revised the pension of the petitioner, Your Lordship. And even as stated earlier, Your Lordship, the ready reckoner is very clear, Lord. This is in consonance with the annexure 3 also, Your Lordship, table 20, Your Lordship. Minimum of the pay, Your Lordship, which I had stated earlier. Like I said, Your Lordship, the petitioner is claiming on basing on this OM, Your Lordship, and this, as per this OM only, we have revised the pension, Your Lordship. Whatever he's entitled, he's already got, Your Lordship, as per this OM, Your Lordship. So there's nothing to be educated, Your Lordship, and therefore Your Lordship, the petition has to be dismissed, Lord, based on this, Your Lordship. If I will be allowed to read the OM, Your Lordship.
Yes, page number.
Page 24, Your Lordship. This is the type copy, Your Lordship. The original is in page 23, but I would like to read from.
Yes.
The undersigned, Your Lordship.
Mm.
Have you got it, Your Lordship? The
Mm.
undersigned is directed to refer to the subject cited above and to convey the approval of Government of Nagaland to adopt the decision of the Government of India in the following manner. The existing provision under Sub-Rule 1 of Rule 19 of Nagaland Service, Rules 2010 is modified as follows. The family pension of pre-1/6/2008 pensioners, family pensioners as revised with effect from 1/6/2008 in terms of Sub-Rule 1 of 19 of Nagaland Service ROP Rules 2010 as notified by the Finance Department such and such dated 10/8/2010. Then, as amended from time to time, shall be further stepped up to 50 or 30% as the case may be of the sum of minimum, Your Lordship, sum of minimum of pay, Your Lordship. Nowhere there's mention of maximum of pay, Your Lordship. Minimum of pay in the pay band and grade pay corresponding to the pre-revised pay, Your Lordship, scale from which the pensioner had retired as arrived with reference to fitment table annexure 3 to the Nagaland Service ROP Rule 2025, Your Lordship. The fitment table, Your Lordship, it's in the ROP, Your Lordship. The
Mm.
annexure 3 table 20, Your Lordship,
Mm.
which the petitioner has also annexed in the
Mm.
affidavit in reply.
Mhm.
Your Lordship, it's at, Your Lordship here. The minimum of pay, it's in serial number 1, Your Lordship. Basic pay in the existing pay, this is 16,400, Your Lordship. That is the minimum pay of the petitioner at the time of his retirement, Your Lordship. And after revision, Your Lordship, notional revised basic pay as on 1/6/2008 is 49590, Your Lordship.
Mm.
So this is 4950, and Your Lordship, if you refer to the ready reckoner, Your Lordship, which is at page 26 of the writ petition, Your Lordship. This is the same as
Mm.
table, Your Lordship.
Mm.
Serial number 20, Your Lordship. 16400 500 200 20,900. This is the scale pay on which the petitioner retired. And next in the under 3, Your Lordship, column 3, Your Lordship, 37,400. This is the revised, Your Lordship, corresponding pay band under the revision, Your Lordship, 2010. This is the revision.
Mm.
It's the same as the table, Your Lordship. And then sum of minimum of pay in the pay band and grade pay is on 1/6/2008 as per fitment table given at Annexure 3 to ROP 2010, Your Lordship. This is the same, Your Lordship, 49550, Your Lordship.
Mm.
So the 5, Your Lordship, the petition, the column 5, Your Lordship, minimum pension, 50% of sum of the minimum pay in the pay band grade, minimum pay as per fitment table, column 4, Your Lordship.
Mm.
This is the minimum of 49590. The 50% is 24795, Your Lordship. So they're claiming based on this OM, Lordship, and we have revised the pension as per this OM, Lordship. So there's nothing left, Your Lordship.
Yes.
That's my submission, Your Lordship.
Mm.
Said. Lordship, may kindly come to page 8, annexure 1 of my opposition. This is how we are fixed.
Mm.
Page 8, Lordship.
Yes.
I've made a statement in paragraph number 7,
Yes.
page 3, Lordship. I may be allowed to read that paragraph, Lordship. Page 7. Page 3, annexure, paragraph 7, Lordship, of my affidavit in opposition, 3 and 4.
Yes.
That with regard to the statement made in paragraph 5 of the writ petition, the answering deponent begs to state that as per OM dated 5/5/2017, the Office of the Principal Accountant General issued revised pension, family pension authority to the petitioner by office authority number so and so dated 13/7/2017. This is not under challenge, okay, Lordship. This is not under challenge. This is how we have revised.
Mm.
He is not challenged that. 13/7/2011-17 to pay revised pension with effect from 1/6/2013. Subsequently, as per office memorandum dated 2012-2017, that's the second OM, Lordship. Annexure C to the writ petition, a revised authority was issued by the Office of the Principal Accountant General by authority number so and so dated 18/4/2018 to pay the revised pension with effect from 1/4/2010. Now, Lordship, may kindly come to annexure 1, page 8. As per the table, the revised, as my learned friend has already submitted, Lordship, minimum So it's coming to 24,795 as per the table, Lordship. As per the table. Lordship has found. We are fixed. As per the table, Lordship. We have not gone beyond the table. Now we are saying, Lordship, if we start giving as per the claim of the petitioner, we are opening up a Pandora box, Lordship. Now, a person who has retired prior to 2000, prior to the coming of the 2010 ROP, we have to pay to every government servant, Lordship, as per the claim of the petitioner. And that's the reason why we have written to the Finance Commissioner, Additional Chief Secretary, in our letter dated 8/12/2022. After all the communication that was going on, and on the representation of the petition also. This will amount to opening up a Pandora box, Lordship. And the fixation has been done in terms of the table. We cannot, the Office of the Accountant General cannot go beyond what has been prescribed, the rate.
Yeah, that's all right.
So, Lordship, there are two authority issued, the page 8, Lordship, Annexure 1, and page 9, Annexure 2, the second authority. So it's already been,
Why two authorities were issued?
Lordship, that is as per 2 OM. One is 5/5/2017, the first OM. And the effective date, giving the effective date, Lordship. And since the 2012/2017 OM also came, where the date has been changed, effective date has been changed. So accordingly, as per the OM issued, we have issued 2 revised OM, pay pension. And basically, the petitioners agreed by this 2 authority that has been issued by us. No, this is not under challenge, Lordship. They have no challenge. They are just making a statement saying that, oh no, I am entitled to the highest. They have no challenge this 2 authority. Because this authority stands as of date. And this is how he has been paid his pension. Nowhere in the writ petition, not even a whisper has been made, Lordship, with regard to this authority, 2 authority that's been issued by the Office of the Accountant General, Lordship. It's not under challenge, Lordship. So, under such circumstances, whether this writ petition survives, Lordship. Because going by the petition, the statement within the petition, Lordship, the petition is agreed by these 2 authority. And like stated by the state respondent, Lordship, though they might propose, it's the authority lies with the Office of the Accountant General.
Yes. Any submission on your part?
Yes, Your Lordship. My lord. Yes, with regard to the entitlement of the revised pension as per the tax pay he has got. Your Lordship, my annexure 1 at page 40, this is also written by the Finance Department. I have approached the authority basing on the rule as well as the OM. Whether I am entitled as per the rule and OM, that is the grievance before this all. The respondents, they are interpreting, they have interpreted in my favor. Now, at the instance of the AG, my lord, AG office, they have U-turned. Your lordship will kindly see the annexure of the AG at page 11, annexure 4 of their affidavit of opposition. Annexure 4, which is dated 8/12/2022. My lord, next page, second last para. Page 12. It is therefore requested to clarify how the provision of Annexure 3 of Nagaland Service revision of pay rules 2010 as indicated in OM number so and so dated 05/05/2017 is applicable to pre-2008 pensioners, family pensioners. Hello, next line is very relevant. It may be mentioned here that if pension is revised as claimed by the pensioner, it will be applicable to all other Nagaland state pensioners which will have a huge financial burden on the state government for payment of pension and various pensions. My lord, nowhere they have said that I'm not entitled under that provision. Now they are bringing that if this is made applicable, then there will be financial burden on the state. That is the only which now they have come. They are not saying that I'm not entitled. If this provision is applied, then there will be a financial burden. But that financial burden actually cannot override the rules, override the OM. Because rule have been framed under the Constitution of India under Article 209. And this type of communication cannot overrule, prevail over the statutory rules. I am citation decision of apex court with regard to pension money.
Okay, you can submit it.
Yes, madam. Now, the question of interpretation of this provision of the rule. That is before. Their content yet is not clear. I am saying that is it.
So, Mr. Muzoe, this financial burden,
Lordship, that is a wrong interpretation, Lordship.
No, it is in the letter. It is
no,
in
no,
the letter.
in your letter also it is there.
Very clear.
Because
But
what,
can that be a ground to deny the claim of the petition?
no, Lordship, what we are trying to say is that if the sole claim of the petition is given, going by the wrong interpretation, Lordship, then you have a huge financial burden on the state. Because
That is of course there.
yes, but the interpretation given by my learned
But,
friend is not that. It's not the intention of the AG, Lordship.
Hmm.
Because we are going by the rules. Because in our letter, we have categorically stated, Lordship. Lordship, may kindly come to page 12, the first paragraph. I may be allowed to reiterate that paragraph again, Lordship.
Page number?
12 of my affidavit of office.
Hmm.
This office, Lordship, has found.
Mhm.
This office has revised the pension of Sri so-and-so retired registrar as per the ready reckoner, which my learned friend has retired upon. Serial number 20 of the Annex 3 of the Nagaland, Government of Nagaland, OM number so-and-so dated 5/5/2017, by this office authority number so-and-so dated 18/4/2018 for an amount of rupees 24,795 with effect from 1/6/2013. As per the 7th ROP, his basic pension is 63,723 with effect from 1/5/2018. So this has already been fixed. Lordship, I have already relied on the two authority of the AG, Annex 1 and 2. Already done. And as per the ready reckoner, Lordship, and as per the
So after this 1/1/2018, he has been drawing basic pension rupees 63,723.
yes. So that has been fixed. He has already got his entitlement as per the table. As per the ready reckoner, Lordship, which my learned friend has already relied again and again, Lordship. No, Lordship, we cannot go beyond what the rule prescribes, Lordship.
No, that could have been expressed in your letter that as per rule we cannot, you cannot cite this financial burden.
No, Lordship, that
That's
was
one of
just a
the-
communication to the government, Lordship. Since they were asking us in the letter again and again. Because like my learned friend has been saying, the state respondent, they are contradicting their own letters. But when the letter was written to us, we being the authority, Lordship, we are supposed to do the fixation as per the,
Yeah, definitely,
yes.
as per rule.
So when the authority, the government has placed the case of the petitioner in front of us, Lordship, after going through all the relevant rules, Lordship, we have fixed it. So we have given our clarification. But if the interpretation, but if the government still wants to give them then you'll have a huge financial burden on the state because we have to start giving to each and every one. That is interpretation and not the interpretation to what my learned friend is saying, Lordship. Because as I've said it in my earlier paragraph, I've already stated whatever his claims are, we have given. And as my learned friend has stated, it starts from the basic minimum. It doesn't speak about the maximum, Lordship. So his basic 16,400 something. So we have started the calculation from there. So what remains now, Lordship? And moreover, the two authority that we have issued in respect of the petitioner, that is not under challenge. He's aggrieved basically by these two authority that we have given, fixing his pension. And as this fixation has been done as per the OM of the 5/5/2017 and 20 December 2017. We have relied on the two OM, Lordship. Not going by the submission of the learned counsel for petitioner, but Lordship, the two basic order by which he is affected is not under challenge. So how can this court interfere and start fixing his pension, Lordship, when the basic two orders are not under challenge? And this order, Lordship, is his document, Lordship. He has not challenged.
Okay. Yes, what are the citations? Yes, madam, you want to say anything?
Your Lordship, the ready reckoner is part of the OM, Your Lordship. and
Yes, yes.
That's the only thing, and he has not challenged this also if he's aggrieved, Your Lordship.
This
The
ready reckoner.
Fixation was done as per the ready reckoner, which is
Uh.
part of the OM of 2017, Your Lordship. This ready reckoner is part of the OM, Your Lordship. And which is also not under challenge, Your Lordship, if he is in fact aggrieved, Your Lordship.
Yes.
Your Lordship, in the reported case reported in 1983, 1 SCC at page 305. In the case of DS Nakara versus India. Para 20, my lord. Relevant para at page 320, my lord. Para 20.
Yes.
May I read, my lord? Para 20. The antiquated notion of pension being a bounty, a gratuitous payment depending upon the sweet will or grace of the employer, not claimable as a right, and therefore no right to pension can be enforced through court, has been swept under the carpet by the decision of the Constitutional Bench in Gauhati Nandan Prasad versus State of Bihar. Wherein this court authoritatively ruled that pension is right and the payment of it does not depend upon the discretion of the government, but is governed by the rules, and a government servant coming within those rules is entitled to claim pension. It was further held that the grant of pension does not depend upon anyone's discretion. It is only for the purpose of quantifying the amount having regard to service in other allied matters that it may be necessary for the authority to pass an order to that effect, but the right to receive pension flows to the officer not because of any such order, but by virtue of the rules. Next, reported in 2000.
So how this observation will help you?
Lord, I'm claiming under the rule, under the oil. Now, the authority is saying some other thing. So now my case is whether it is covered by the rule or not. That is the relevance. I'm coming for enforcement of the rules. Since it has not been enforced in my case. That's why I'm before this court. And the department has clearly come in my favor. but subsequently they have taken a U-turn. So now, the correct interpretation of the rule that has been provided by the state governing the pensioners, that is to be interpreted by this honorable court. My lord, in the case of State of Rajasthan and others versus Mohendra Nath Sharma, 2015, volume 9, SCC, page 540, para 28. Para 28, 31, 28. Para 28 at page 550. Yes, madam. It is a well-settled, well-known principle that pension is not a bounty. The benefit is conferred upon an employee for his unblemished career. In TK Nakara versus United India, DA decided speaking for the bench to find that the approach of the respondent raises a vital and not too easy of answer. Question as to why pension is paid and then why it was required to be liberalized. If the employer is the employer, which expression will include even the state bound to pay pension? Is there any obligation on the employer to provide for the erstwhile employee even after the contract of employment has come to an end and the employee has tender service? Next, what is a pension? What are the goals of pension? What public interest or purpose, if any, it seeks to serve? If it does seek to serve some public purpose, is it thwarted by such artificial division of retirement pre and post and certain dates? We need seek answer to this and incidental questions as to render justice between parties to this petition. Para 20, the educated notion of pension being a boundary gratuitous payment.
No, that is a quoted from the.
Employer not claimable as a right, and therefore no right to pension can be enforced through court has been swept under the carpet by the decision of the Constitutional Bench in Anand Prasad versus Rubia, wherein the court authoritatively ruled that pension is a right and the payment of it does not depend upon the discretion of the government, but is governed by the rules, and the government sovereign company those rules is entitled to play. Now, para 31, next. Para 30 of the sixth judgment. Para 31. It is urged before us that it will put a heavy financial burden on the state. The said submission has been seriously rejected by the Learning Council for the respondents by urging that hardly 200 to 250 retired lecturers in the selection scale are alive in presently, and the state cannot take the degree of financial burden to deny the legitimate use of the respondents. Next para 31. In view of the aforesaid analysis, we do not perceive any merit in this special appeals and accordingly to the same extent dismissed. The benefit shall be extended to respondents within a span of 3 months from today, in which the group sum shall carry interest at the rate of 9% per annum till regularization. There shall be no otherwise supposed.
No, multiplication is not necessary, as because basic principle is also not challenged by them. Now the question is only this interpretation of this memorandum of.
Yes, correct. So in my case,
So they have not denied that you are not entitled to any pension.
yes, yes, yes. So my lord, the basic question issue that is before this body, the interpretation of this word. My lord, since it is mentioned that shall be further stepped up to 50% and 30%, as the case may be, of the sum of minimum of pay in the pay band, and the grade pay corresponding. I know corresponding, this is a very important word, corresponding to the pre-revised pay scale from which the petitioner had retired. So my lord, corresponding to the pay scale from which the petitioner retired. So since the petitioner retired at the apex pay scale, I know his revision of pay pension has to be done according to that, not on the minimum. That is the What I'm making submission, this is my understanding. As per this oil, my understanding is that I'm entitled for the maximum. And my lord, the subsequent notification, this notification restricted the revision of arrears, the arrears on the revision pension up to 1st June 2013, from 1st June 2013, but the subsequent notification has changed the date to 1st April 2010 by the subsequent notification. That is notification dated 20 December 2017. So my lord, I have represented to the authority that the annexure which was enclosed as annexure 1 in the OM dated 20 December 2017, that is erroneous. So my revised pension should be fixed as per annexure 3 and the highest pay from which I expect. So that has been accepted by the finance department. Subsequently, they have now returned. Now the question of interpretation of the OM and the rule, ROP rule 2010, that is. My submission is I'm entitled as per the OM, I'm entitled to get the pension.
This OM dated 5th of May 2007.
What my lordship, I will not stretch much of the time of the court lordship. Now, much has been stressed upon the two OMs. 5th of May 2017 and 20 December 2017 OM, where my learned friend is saying that I am entitled under that lordship. Query has been made to us, to the Office of the Accountant General, through the Office of the Finance Commissioner, with regard to the interpretation of these two OMs, lordship. Now, we have refuted all the steps taken by the state, saying that no, your interpretation is wrong. Ultimately, we issued the two authority, which I have already read. We have done the fixation according to that, the two OMs. Petitioner has not challenged this two authority, which we have issued. Because they are challenging our authority, firstly, lordship. If you go by the read petition, lordship, they are saying finance is right, we cannot do it. Basically, his challenge is towards our authority, lordship, in the read petition. They have not challenged our authority that we have issued. Secondly, lordship, the letter dated 8/12/2022, annexure 4 of my affidavit in opposition. This is the basis on which the government has taken the decision to stick to what the office of the AG has stated, lordship. So this letter is also not under challenge. This is how he's been affected, lordship. We have brought to the notice of the court. See, this is the letter which says that no, you cannot ask for more than what is entitled to you. They have not challenged this letter also. Letter dated 8/12/2022. This letter clarifies the interpretation of the 5th May 2017 OM and 20 December 2017 OM. This is not under challenge, even this letter. Now the authority relied upon by my learned friend lordship has got nothing to do with the present case. If we have deviated from the rules, the ROP, then, and the subsequent OM that has been issued, if there's a deviation from our part, lordship, as per the chart, fixation has been done as per the entitlement of the petition, which we have done. The interpretation given by my learned friend lordship with regarding to deviation from the rules. Had there been deviation from the rules, they have to prove it. In facts and figures, lordship, they have to prove it. Just by making a bold statement in the petition, no, lordship. They have to prove it. No, from this, I am entitled for this rate. They have to prove it. They have not done it, lordship. They'll just make a statement in the petition. Nothing in facts and figures, lordship. Whereas we have put on record, in the form of an affidavit, lordship, how the petitioner is entitled to. And when my documents are not under challenge, lordship, whether the read petitioner has a locus standi to come before the honorable court without challenging the basic orders. The petitioner wants the interpretation of the rules, whether lordship, this court can interpret the rules. They have to challenge the rules then, lordship, ultimately. If he's aggrieved, let him, because his benefit came from the rules. His all benefit came from the rules. There is no deviation from the rules, lordship. That's what basically we are trying to say. And state after our explanation as to the interpretation of the OM and the rules and the Government of India notification, lordship, we have clarified to the Office of the Finance Commissioner. That's how they have rectified. They have rectified their stance. And nothing else, lordship. And the last rectification that we have given is not under challenge. This is a basic letter, which is not under challenge by the petitioner.
Okay.
Obliged, lordship.
One important aspect is my letter is trying to mislead the court. I want to point out their letter. This is the entry's letter, my lord. It is annexed in my. Lord, in the kindly see page 30, annexure E. This is in reply to my representation to the AG. This is dated 1st October 2021. This is addressed to the petitioner. Subject: implementation of the decision of the Government of India, revision of pension, family pension of pre-106/2008 pensioner family pension. Sir, in inviting a reference to your letter number NIL dated 23/8/21 to the subject cited above and to state that this office has revised your pension at the rate of ₹24,795 per month. That is 50% of minimum of scale of pay plus grade pay with effect from 01/04/2010 as per Radio Recorder Annexure 3 of Government of Nagaland, OM number so and so dated 5/5/2017. Wherein the Government of Nagaland has not adopted the inclusion of 24% of carriers relief with grade pay in the said OM dated 05/07/27. Further, it is mentioned here that the modification of fixation of pension is on a multiplication factor of 1.86, that is basic pension plus various pension plus generous relief of 24% has been accepted by the Government of India. Is required to be adopted by the Government of Nagaland in respect of the pensioner family pension of 3/01/06/2008 of the state of Nagaland. The Office of the Principal Accountant General A and E Nagaland is the pension authorizing agency and not the pension sanctioning authority. But here the sanctioning authority, that is the finance department. They have already verified those. Here they have also mentioned that it has been worked out as per annexure 3. Here in this letter. Now, in the same brief, they are saying that annexure 3 is not applicable. In return, they have mentioned that yes, you approach the sanctioning authority. So I have approached. The sanctioning authority has verified. I have questioned the annexure 1. That annexure 1 has been issued, clarifying basing the minimum scale. That is fixed at 16,400. So that works out, 50% of that works out to 24,795. That is the minimum. So in that scale, my lord, S20, the scale, the initial scale is 16,400. And apex is 20,900. So I have rendered my service and reached up to 20,900. As per this OM, since it relates to pay band, pay scale in the pay band, if it is off the pay band, then they would be right, minimum. But in the payment there are so many basic things, starting from 16,400 till 20,900. My submission is that as per OM, and this position I have represented to the authority, it is the sanctioning authority. When the sanctioning authority has accepted my contention, my submission, my claim, now the implementing agency they have twisted and they have prevailed about the
Sanctioning authority.
sanctioning authority. Otherwise, the sanctioning authority has accepted my claim by both the letter and direction was given to revise. And I'm claiming my right on the basis of the this rule and OM.
Okay, we'll see.
But
Third, Mr. Your good name, please.
NK will come.
And Kelly,
NK will come.
Learned Counsel for the petition. And Miss Madam, your good name?
Ina Holi, Your Worship.
Ina Holly, learned government advocate for the state respondent number 1 and 2. And Mr. Mozoy, learned standing counsel for the respondent number 3 and 4. Argument concluded, judgment reserved. Can you give the judgments in this Xerox copy of the judgments? Because no, list will not do. List will not do. You give the. Yes.
For hearing item number 23.
Lordship, if Lordship, if I need turn to page number 17 of the writ petition, Lordship.
Page
17 of the writ petition, Lordship. Point number 9.
yes.
May I read, Lordship?
Mm.
Appointments under this scheme, irrespective of the appointing authority specified under the rule, shall be made only with the approval of the respective.
Page number 17.
Lordship, page number 17 of the writ petition, Lordship.
Yes, it is a copy of the office memorandum.
Lordship. Point number 9, Lordship.
Yes,
May I read?
yes.
Appointments under this scheme, irrespective of the appointing authority specified under the rules, shall be made only with the approval of the respective heads of administrative departments, with the prior clearance of the Department of PNAR reforms.
Mm.
The departments should send proposal for appointment on compassionate ground as per the format enclosed, Lordship.
My lord, Chair, the state respondent has terminated the service of the petitioner, my lord. However, here, my lord, here, appointment letter issued to the petitioner and the termination letter issued to the petitioner is the same authority, my lord. Same authority. The appointment is authority as well as the terminating. Same person has taken the step, my lord. So how can that be possible? That is my question to the state respondent, my lord. So, and now here, I think appointed way back in 2015, and after serving for 21 years, I was terminated from service on 12 May 2016, my lord. Just only on the ground that government has not approved for the appointment of the petitioner, my lord. And thereafter, in the year 2007, 24 posts has been created, and there also the appointing authority also the same, and also the order, all the contents has been changed. It does not mention about the approval of the government, my lord. Even yes, there is. May I take the lordship to annexure G, my lord, annexure G, page 25, my lord. Married, my lord. Government of Nagaland Home Department Secretariat Administration Branch B order dated 28 November 2017. Considering upon redesignation of 26 posts of personal peon created by this department order number so and so, dated so and so, to that of office beyond why this department order of even number dated so and so, the following person are hereby appointed as regular office beyond in the Nagaland Civil Secretariat, Kohima, in the revised pay band will be so and so. So and so with grade pay of will be so and so plus all other allowances and as are admissible under rules from time to time with effect from so and so. My lord, so this is the new appointees who have been appointed by the creation of 26 posts, my lord. And now we annexure I here by this order, 5 person has been appointed, and these are the person, those were terminated along with the petitioners, my lord. These 5 persons, my lord.
They were reappointed.
Yes, my lord. Here,
They were earlier discharged along with the petitioner.
yes, my lord. Here, my lord, if we compare, my lord, here in the new order where they have been reinstated, my lord, this serial number 1, serial number 1 is at serial number 4 of the termination order, my lord. And serial number 2, Kevino Katso is serial number 6. And Imdumar Longumar is serial number 7. And A Shikani Sumi is at serial number 3. And Mua Kamsuk is at serial number 9, my lord. Out of 11 persons, here 5 were reinstated by order dated 2 September, yes, 2 September 2019, my lord. This is an answer, page number 28. May I read the order, my lord?
Not necessary.
Yes, my lord. My lord, annexure J is the legal notice where the petitioner has given to the state respondent to consider the case of the petitioner by reinstating in the service model. However, the state respondent has not considered the case of the petition. And now,
So, now tell me, while dismissing you from the service, whether any notice was issued to you?
no notice was issued.
No notice was issued.
Without prior notice, they have just come out with the order. And my lord,
And while you have been appointed as peer in the group D post, group D post. So what is what was the probation period? 1 year? It was a regular appointment or it was temporary appointment?
I was appointed on regular basis.
Where is that appointment letter?
Appointment is letter is annexure
Page 20, Lordship.
Page 20.
May I read, my lord? Page number 20 and type copy says page, no, it's not that one. Just at page 20.
Yes.
Government of Nazareth Home Department Secretary Administration Branch B order dated 13 May 2015. Number so and so, consequent upon redesignation of 11 posts of personnel beyond created why this department dated number so and so, dated so and so, to that of office beyond white order number so and so, dated 12/3/2015. The following persons are hereby appointed regular office beyond in the Nagaland Civil Secretariat Kohima in the revised pay band of rupees so and so, with grade pay of rupees so and so, plus all other allowances as are admissible under the rules from time to time, with effect from 1/6/2015 onwards. That is, okay. And number two, the above appointment is made under the terms and conditions as laid down in the new defined pension schemes notified by the Finance Department application number so and so dated 28/1.
So, madam, regular appointees, can they be dismissed this way, in this way?
Lordship, yes. because
Without,
they-
without issuing any notice, without giving them any opportunity of being heard?
No, Lordship, but,
So had they been appointed as temporary employee or contingency basis, then the position would have been different. Even in that case also, you are not entitled to dispense with their service without issuing notice in case of temporary employee also. But here, the person was appointed as regular office peon. You see this appointment letter.
Lordship, but, Lordship, may kindly come to page 5, annexure A, Lordship.
Annexure?
Annexure A of my affidavit in opposition. If I may read, Lordship. Lordship, it says, the redesignation of 11 posts of personal peon as office peon, Lordship. Issued by order number such and such, and the subsequent order of the following persons as office peons against those posts issued by order such and such stated were all found to be done without the approval of government, Lordship. So for that reason, Lordship, their appointment was cancelled, Lordship. And Lordship, if my Lordship may kindly come to page 6, Lordship. Annexure P, Lordship. Lordship, in the year 1965, Lordship, that is 24/09/1965, Lordship. 26 personal peon posts were created, Lordship. But after many years, after a gap of 52 years, Lordship, in the year 2017, that is 17/10/2017, Lordship, the department was facing a shortage of peons, Lordship. And since personal peon posts were becoming redundant, Lordship, over the years, the department, they decided to divert or redesignate, Lordship, the 26 personal peons to office peons, Lordship. In this.
Now, my lord, as per the affidavit filed by the state respondent. Now, they have stated that I have been placed at serial number 35 as my application has submitted only on 6/3/2018, my lord, which is not true. Why? Because right after the expiry of my father, I submitted and according to
That you cannot, you cannot assert that because there is no date in your application.
But my lord, I've been appointed in May 2015. However, as per the serial shown by the state respondent, why? Because when a person is died, accordingly the serial is maintained as per chronological order, and there they are trying to show that my serial stand at 34. So I'm not entitled of appointment as of today. Why? Because my serial has, my serial has not been reached. So that's what.
So now you are in serial number?
34.
No, Lordship, I have the recent
Yes.
list, Lordship.
Yes.
So the petitioner stands at serial number 13, Lordship.
Pardon?
Serial number 13, Lordship.
Serial number 13.
13, Lordship, yes. As on January 2024, Lordship.
So when it can be expected then?
So if Lordship may Grandson, the thing is, Lordship, we just can't supersede the other, because all these are.
No, no, you are not required to supersede.
Yes, Lordship. So all these are compassionate applicants, Lordship, please. So the petitioner stands at serial number 13, Lordship. So
No, but that's all right, but it appears that some kind of illegalities have been committed while dismissing him from service. So without issuing notice.
There is one, and my lord, may I take your lordship to the affidavit filed by the state respondent in Lord Annex, page number 2. Page number 2, paragraph 4, my lord.
Yes.
That we regard to the amendment made in paragraph 5 of the petition, the application for appointment under compassionate ground submitted by the petitioner, nor the record files of the receipt is available with the department as per the record files of the department. Therefore, the adjoint department are unable to clarify the status of the nature of appointment as claimed by the petitioner in the application that led to the appointment on 13/5/2015. However, on the basis of appointment order issued by the department, it is clear that the appointment of the petitioner on 13/5/2015 was not done under the consideration of commissioner. The petitioner was
Compassionate case.
Yes, the petitioner was appointed as per the terms and conditions of the order number so and not on the basis of compassionate ground. My lord,
So if the person concerned is not appointed under this scheme, compassionate ground scheme, then why approval is necessary? Approval of PNR department is necessary?
Lordship, for every appointment, approval is necessary, Lordship.
Every appointment.
Lordship.
So is there any notification of the government to that effect? Is there any notification of the government that for every appointment approval has to be taken from PNAR department?
Lordship, as stated in the OM, Lordship.
That OM only for compassionate appointment
Lordship.
or for other appointments? You have referred to page number 17 or like that? This approval is only for this this compassionate appointment.
Lordship.
So your affidavit shows that he was not appointed, she was not appointed under compassionate scheme appointment. How do you explain this? Hmm?
yes, that is not clear.
Pardon?
Paragraph 4.
Pardon?
As per the reading of paragraph 4,
Hmm.
the son is not clear, and they have terminated me, and which shows that they have taken the step in most illegal manner. They have just followed chosen big policy. Why? Because 11 of us were terminated, 5 were reinstated.
Appointed.
Yes.
They were not
And-
reinstated, Lordship. They were fresh appointments, Lordship.
But it implied that. And my lord, my father
So,
was died way back in
madam,
2014, and today's 2024.
Okay,
Now
okay.
it's almost
Okay.
10 years that my father was expired and I'm starting. The petition is starting. I'm longing for the appointment, and the state respondent is not taken any initiative.
So if there is any office memorandum or any notification regarding taking of approval for regular appointment, you produce it. If available.
Lordship.
Hmm? So this page number 17 will not come to your rescue. And you have taken contradictory stand also in your affidavit. Hmm. What to do? So, if that notification or any office memorandum is available, you produce it before the court. First thing. And secondly, you obtain instruction from the department
Lordship.
that prima facie it appears that some illegalities have been committed in case of the petitioner. So, are the government, are the department is ready to engage him again in whatever scheme, either in compassionate scheme or in this way, regular.
Lordship, yes, the petitioner's case will be considered, Lordship, as and when her turn comes, Lordship.
No, it may take or 1 or 2 years. Would it be possible this year?
That I have to.
Hmm. So let us fix it as partnered on Tuesday. In the meantime, you obtain instruction from
Lordship.
them. Hmm.
Lordship.
So you tell your department that the court is prima facie of the view that some illegalities is committed while discharging him from the service. So either way, are they ready to engage him again? Huh?
Lordship.
Tuesday then. Third, Mr. Your good name? Learned Counsel for the petitioner and Madam
S. Chang.
S. Chang, learned government advocate for the state respondent. Heard in part, leaves the matter on Tuesday as partnered. Yes, yes.